Good morning, everybody. Happy Tuesday. Welcome to TCF Live. My name is Dan Soul, along with my trusty sidekick, Ellie. We will guide you on this 3-hour journey through Courtlandia, starting with Judge McNally.
License in a speeding charge. You have the right to an attorney. If you would like one, I will provide you with one at public expense. Would you like an attorney to represent you?
Yes, sir.
Okay. Just be patient. We're going to put you in a breakout room. We'll set you up with the lawyer.
Okay, thank you so much.
All right. So just we'll be with you momentarily. Thank you. Are you here for Mr. Kazmarek, counsel? Ms. Barrett?
No, Your Honor, I'm here for, no, I'm not. I'm here for waste management. There's a ticket, case number ends in 5038 A, B, and C.
Did you already talk to the prosecutor?
Yes, I did, Your Honor.
Do we have the file yet? John, go grab that, will you, please? Morning, Shane. How are you?
Morning, Judge.
What's going on with the?
New fire extinguishers. Swapped out.
Okay.
Judge needs waste management files in.
Lisa, do we have anybody here yet besides Ms. Barrett?
Yeah, I've had a few people in the breakout room. Mr. Kennedy's here for sentencing.
Is he with his lawyer?
Yes.
Okay.
Um,
Can you make sure they start bringing these files in a little quicker?
Yeah.
Thanks.
You're welcome. I'll let her know.
Mr. Johnson, just stay in that breakout room. I'll put the attorney in there when they're ready.
People
Oh, okay.
Against Waste Management, 26 SO 25038 A, B, and C. All right, good morning. Your appearance?
Your Honor, good morning. Carrie Barrett on behalf of Waste Management. My P number is 42711.
Right, so you're going to plead to count one. This is let's see, let me double check something. All right, you're going to plead to overweight violation. That's count one with agreed upon fines and costs of $3,000. And then you're also going to plead responsible
Yes, Your Honor.
to both defective equipment cases. True?
That is true, Your Honor.
To the charge of overweight violation, how do you plead, responsible or not responsible?
Responsible.
And to the first charge of defective equipment,
Responsible.
file B, and this count 3 hydraulic leak, it says responsible or not responsible.
Responsible.
Okay, I'll accept the plea to overweight. I'll accept the plea on file B. I will assess fines and costs of $3,000 on the overweight. I will assess fines and costs of $225 on both defective equipment charges. And all payments are due on August the 21st. Okay? Have a great day. Thank you.
Thank you. Have a good day.
You too. Thanks.
Bye-bye.
Do I have any victims here on the Kennedy case at all, Lisa? And there's a whole bunch of them here, and I'm gonna list their names here. James Allen Kennedy, 26G 703768. Good
Morning,
morning,
Judge.
Mr. Kazmarek. Your appearance?
Jason Kazmarek on behalf of James Kennedy.
Your name, sir?
James Kennedy.
All right, before we begin, I need to inquire whether or not any of the victims are here. So I'm going to ask Lisa, do you have Ron Rose here, or Trevor Yarbrough, or Maria Mariah Gullett or Robert Spalding III. Are any of those individuals in the building? I'm sorry, on Zoom.
No, not on Zoom.
Okay, I just need to double check. We set this for 8:30. There was a no contest plea to operating while intoxicated, first offense. The super drunk charge was dismissed. Have you had a chance to review the report with your client? And are there any material additions, corrections, or deletions?
I believe so. We have reviewed it.
No, deletions, corrections?
I don't believe so.
Okay. Anything you'd like to say on his behalf?
Yes, Judge. So obviously this offense date was December of 2024. He's been kind of incident free for, well, quite some time, 19 months, 20 months,
Kind
whatever
of
it's
cutting
been.
out. Hang on, you're kind of cutting out.
Sorry. So yeah, so my client, this offense date was in December of 2024. My client has largely been he's been incident free since then. This is kind of a wake-up call. I know he was a bit more wild in the past, as record may indicate, and this is really this is a wake-up call. To some extent, where he is, I know he is obviously used, as indicated by his interview with probation. He admitted some recent use, but he has not refused to drink and drive since December of 2024. So he's trying to be cooperative. In fact, he was cooperative with the police. He was waiting for quite some time for actually this charge to come. He had been checking into it for a long time. It took a long time to actually get this thing charged, and it was then cooperative once he did turn himself in. My client does work at Dale's Car Wash. He doesn't earn a ton. It's $500 a week, so the financial responsibility is going to be fairly difficult for him. I know they ask him test twice a week. I know that there is fines and costs to pay, so I know that there's going to be financial hardship for him. As far as the AA meetings, I know the court usually likes them in person. He has started those. He's completed 6 of those AA so far since the pretrial. He would like the opportunity to be able to do some via Zoom. His license, as you know, is suspended from the second. Well, you may not know, but likely it's suspended from the Secretary of State currently until mid-August. So he's asking if some of those could be done by Zoom because it's difficult to find a ride, as well as when he does have to appear for the court for to be his probation officer or whatnot. He's asking if that could be on Friday because he will have a ride on that day, and it's his day off work. So that's all I have, Judge. That's all I have.
Anything you would like to say, sir?
No, that sounds it.
I cannot hear a single word you're saying, not even close.
Nope. That sounds about all. Thank you, Your Honor.
Well, you caused an accident and you hurt some people. And now here you report, and I'll give you credit for your honesty. After I told you not to consume alcohol or drugs, you still did. You used cocaine.
That was the weekend before, Your Honor.
Well, you said the day before the screening. If you were screened on the 30th, the fact is that you still not listen to me very carefully. I'm going to take you at your word that you're talking about the 29th. But still, you're awaiting a court date. You hurt some people. You caused an accident. You're using cocaine as you come into your court date. So yeah, I'll stand corrected. You didn't violate a bond condition, but you did commit an illegal act. Now, you better take this a lot more serious than I sense that you are. Two years probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You do have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs, and ETGs. I would make it weekly for 4 months, then bi-weekly for 8 months if you're clean, then monthly for the duration of probation if you're clean. No kratom, no poppy seeds, no CBD oils. You consume, it will be deemed a violation. Those items are prohibited. And if you consume those items, that will be deemed a violation and your probation will be affected. Do you understand that?
Sir.
I'm going to order that you attend AA. I need you in an intensive outpatient treatment program. I want you going 3 times per week, in person, until you're in an intensive outpatient treatment program with aftercare. Once you get in the intensive outpatient, you no longer have to attend AA or NA. You have to go in person. You're to attend the Victims Impact Panel. You understand all of that?
Yes.
You're to serve 10 days jail credit, 1 serve 9. I will let you, this being a first offense, serve those on the court work program. There's a $35 a day charge for that. So your total court work program fees should be $315. You're to pay fines of $300. Cost $250, 75 victims' rights fee, $50 justice assessment. So fines and costs here, excluding court work program fees, are $675. Screening fees $60 for $735. Cost of recovery is $225 for a total of $960. You have probation fees of $480, bringing your total to $1440 plus the court work program fees. Double check my math there, Lisa. I think it should be $1,755. You may be eligible for early discharge from probation pursuant to statute. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. If you violate, you could receive 93 days jail with credit for 1 day served plus any time you successfully complete on the court work program. I'm not going to be real patient with you, Mr. Kennedy.
I understand.
I expect no use. I expect full compliance. We understand one another?
Yes.
All right, Mr. Kazmarek, why don't you tell me what he can afford to pay and when, how much? Can he pay anything today?
Go ahead. I can do, I'd have to check my bank account, but I think I could probably do 500 today, and then depending on the drug test cost and when I have to pay everything, I could probably do like 300-400 monthly.
I'll tell you what, you pay $500 by 4 p.m. today. I'll have you pay $150 bi-weekly. I'll start that beginning on August the 10th. If you ever need more time, no problem. Call the court. We'll go on Zoom on or before the due date, or you can come here and I'll be glad to give you an extension. You understand? Just don't ignore me, okay?
Yes. Can I pay that online? I was supposed to go to work right after this.
Yeah, but here's the thing. I really want him to be instructed today. What time do you have to go to work at?
I was supposed to be there at 10.
He's got a ride. He's waiting in the parking lot, but
All right, here's what I want you to do. Mr. Kazmarek, write this phone number down. Tell probation that 734-671 extension 245. And you can tell him the judge asked you to call. He's going to let the defendant go to work today, but he wants him to set up a reporting time for them to instruct him on the initial judgment and give him a copy of the judgment, order of probation, and maybe they'll have him come in tomorrow. I don't know, but I'll let you guys work that out. So 671-0201 extension 245. Okay.
yeah. Thank you, Judge.
Thank you. Have a good day.
You too.
People against Nicholas.
Good morning once again, everybody. It is TCF Live on a Tuesday. What are we on? Episode 337 today? Yeah, 337. We just keep piling them on, don't we? Yesterday, all the courts came to us at once. Today, they're kind of trickling in. We'll continue to ride with Judge McNally for a bit.
431 on behalf of Nicholas Sakala.
Sir, your name?
Sakala.
what are we doing on this? They didn't send in a stip form. Did you talk to them?
Yeah, Your Honor, what happened is there were two policing agencies on this. The Grozil, we didn't get the video from Grozil. They're looking into whether or not they do have the video. That's all we're waiting for, and I think it will be resolved.
So what, you
This
guys,
is a OWI with a Watercraft, Your Honor. You know, the
Yeah, you
sheriffs
just-
were involved, Grozil was involved. We got the, now, the sheriffs didn't have any video, just a report. And I'm assuming that the only video that we're gonna be receiving, if there is any, is from the Grozio Police Department. And then the guy, the officer that was in there, he was supposed to check on it today as well.
so what do you want to do? 2-week adjournment? She didn't write anything down. They just sent the file in.
Yeah, yes, Your Honor.
Alright.
Whatever's good for you.
How about August 4th? Is that good for me, Lisa?
Yes, August 4th at 8:45.
Okay,
That sounds great.
all right. And you're comfortable she's gonna take care of doing what she has to do. Did you speak to Ms. Esmaro?
Yes, and not only
Okay.
that, Your Honor, we contacted Grozio too.
Okay,
So we both have contacted Grozio. They both know we need a response on this as soon as possible. I'm assuming we're gonna get by the end of the week.
okay, good enough. We'll see you on the 4th. Have a good day. Good luck, sir.
Thank you, Your Honor.
Thank you. All right, people against, all right, priority. Where is she putting these? I don't know what we're doing on this one, is Trombley. I'm gonna just call, this is priority waste 26 SO2 5 cases we got.
There should be 3 files, Your Honor.
037 A, B, and C.
Good morning, Your Honor. Elizabeth Trombley appearing on behalf of Priority Waste.
Give me a second here.
Okay,
All right, so on this one, there's gonna be a plea to overweight with agreed upon fines and costs of $1,000.
that's correct.
And, then that's on count 1 through file, 37A, and then it looks like she's dismissing after you plead to that, files B as well as C on that one. Is that correct?
That's correct, Your Honor.
Authorizing another's plea on behalf of the company
Yes, Your Honor.
to the charge of overweight on count 1. How do you plead, responsible or not responsible?
Responsible.
Plea is accepted. Fines costs on that are $1,000. On motion of the prosecutor, I'm dismissing files B and C. And now I have 26 SO25042A. Geez. A and B. We're gonna take that one, I guess, next. That's gonna be a plea to overweight on file 42A. And there's going to be fines and costs agreed upon of $2,000, and then you plead to that, and she's going to dismiss on her motion, file B, right?
Correct, Your Honor.
To that charge of overweight, responsible or not responsible on file 25042A.
Responsible.
Plea is accepted. Fines cost $2,000, pay by August the 21st. I'm dismissing 42B altogether on motion to prosecutor. Now, finally, I have people against priority waste, 26SO25041, A and B. All right, your appearance again?
Elizabeth Trombley appearing on behalf of Priority Waste.
Now, what are we doing on this one? Let's see, I don't have the. All right, there's gonna be a plea to overweight with agreed upon fines and costs of $1,400. The defective equipment to be dismissed, correct?
Correct, Your Honor.
You're authorized to enter that plea on behalf of the company
Yes, Your Honor.
to that charge of overweight, responsible or not responsible.
Responsible, Your Honor.
Plea is accepted, $1,400, paid by August the 21st. And I'm gonna go ahead and dismiss file B, the defective equipment on motion to prosecutor. Have a great day. Thank
Thank you,
you.
you too.
People against, Hughes. This is Michael Wayne Hughes, 2-3G 706009. Counsel, your appearance, please.
Good morning, Your Honor. If it please the court, Attorney Andrea Fanning, P42853. I'm appearing with my client, Mr. Hughes. Mr. Hughes, can you unmute yourself and state your name?
I don't have him on Zoom, Judge.
Oh my God. Okay, because he said he was in the waiting room.
All
I
right.
guess.
I do
Can
not
you-
see him.
Can they not get you this digital? I'm gonna be gone the week after. I really don't want to go all the way to mid-August, but we'll talk about that. I'm thinking I give you a week on the PCC and another week on the preliminary exam. So
So you're gonna put me the 28th and the 4th?
Is if you can do that. So let's get your client. Call your client first and let's get him
I
in here,
I
okay?
just called him, Your Honor. That's why I thought he was in the waiting room.
All right,
Because
well,
I
I'll go on to another
literally,
case till he shows up, okay?
I appreciate it. Thank you.
Amy Lynn Thomas, 20T 6354758.
Your Honor, she's in custody with that Trent. They're not there.
A and B. Amy Lynn Thomas. Can anybody hear me over there at the police department? Call against you, please. How you doing?
I'm well, thanks. How about yourself?
Not too bad. Good morning,
I got Miss
Detective.
Thomas, 1 second.
Okay.
I'll bring her in. Now we're going. All right, Ms. Thomas, just stand on this red X right here and just make sure you speak loudly so that the judge can hear you, okay?
Okay.
Name,
Amy Thomas.
counsel, your appearance.
Good morning, Your Honor. Attorney Corey Westmore, I'm hearing on behalf of Ms. Thomas.
Is she seeing me at formal reading?
That's correct. Yes.
So where has she been for the last 6 years?
Your Honor, she was incarcerated in OCJ about a year ago.
Yeah.
Sent in plea by.
And I must have responded. I don't not respond to these. Let me double check.
So she thought that this was third up.
Oh, I told them to set an arraignment pretrial after July 18 of 25, and I said, send notice to jail. Excuse me, in defendant's last address. And that's what we did. And then she didn't show up.
Assuming that she did not receive that.
Why are you making that assumption? You think she,
I'm sure you can live with it.
you don't like to show up, Ms. Thomas?
That I never received it. If it was sent to the last address at file, it was the address that was on,
2,
it was
3,
a DIOP
5.
address.
Slow down. Let me talk. You have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18 warrants is all. Well, congratulations. You want to play games with courts, it's not going to work out well for you, ma'am. Ma'am, if I were you, I
Yes.
would stop on this little, I didn't receive it type thing. Okay, come on. I don't want to hear it. Tell some other judge in some other court, in some other county or some other state that. I don't want to hear it. Does she work?
I don't, so.
She stands mute, waives formal reading
That's correct.
on both? I hope she's got some money because I'm not gonna put up with this nonsense. You gotta show up in court, ma'am. I don't know who you think
Yes,
you
I
are. You
understand
cannot
that.
ignore courts all over this state like this, okay? 4,010%. I hope you can post. They'll let you make some calls. Your court date will be on July the 30th. That's the earliest. Is that the earliest I can give her, Lisa? Or
Let me check. Yeah, they're not here this Thursday because Judge Hessen is off.
1,010%. You're gonna have to post that or you're gonna be in custody for 9 days. Stop doing this, okay? Stop doing this. And you have to show up on July the 30th at 9:30 in the morning, even if you post. If you
Yes.
don't, it'll be 40,000 next time. Do we understand one another?
Yes.
You had enough correspondence from us. You knew to show up. And if I were you, I'd start going over to these other courts. Judges don't like this. Maybe some are more understanding than I am, but I'd like to know who you're gonna stop this nonsense. You're gonna learn a lesson if you don't stop. That's it. Good luck. Have a good day. Have her fill out a petition for a court-appointed detective, please.
Thank you, Your Honor.
Can I have Zaheed Nasser Khan, 26M 706 806 A and B? Do I have Trooper Martin here?
No, not on Zoom.
Is Zaheed Khan here?
Yes.
Mr. Khan, good morning. Your name?
Zaheed Khan.
All right, well, I hope you slow down, but today's your lucky day. I gave him 15 minutes. It was scheduled for 8:45. It's 9:12. Case dismissed. The officer failed to appear. You're a winner. I hope you got insurance though, okay?
I do got insurance, sir. Thank you very much.
Good luck to you. Thank you.
Thank you.
People against. Slayton, Paul Michael Slayton Jr., 26M 709 895. This is another Trooper Martin case. Nobody showed on this, neither the defendant nor the officer, right?
Correct. Neither one's on Zoom.
So plaintiff, the officer and the defendant failed to appear. Case dismissed.
Alrighty, friends, good morning once again. TCF Live. Let's change it up a little. Courts are still slow to open up this morning, but we do have a little bit from Judge Oakley, so let's go there.
Mohammed's on.
Yep. Mr. Mohammed, your appearance.
Good morning, Your Honor. Mohammed on behalf of the people.
Thank you. You are Asia McKay? All right. You filed a motion to set aside a conviction, correct? All right. Mr. Mohammed, what's your position?
Your Honor, I have not received a copy of the defense's motion. I'd respectfully request for a 1-week adjournment so that she can submit a copy of that to me. I can review it and have a informed decision for the court next week, if that's okay.
Any objection to a 1-week adjournment, ma'am?
And Your Honor, I do have a copy of my card. I'm going to approach the defendant after this hearing and give her a copy of that. Would include my email, so she can just email it directly to me.
Okay, understood. He's going to give you a copy of his business card so you can email it to him. What's that? I guess you'll have to scan it then. I mean, you know what? Well, you'd have to wait an hour. Library's open at 10. You could do copies there. I'll leave that to you. You got to get the documentation to him somehow. If you want to email it and scan it and email it, or if you want to make copies and just hand them to him. All right? Okay. All right. So next week, 9 o'clock.
This week?
9 o'clock, okay? All right. Good luck. Just Tuesday at 9. Yep.
see Mr. Mohammed before you leave so he can give you the information?
He just did.
I didn't even see him come in, sorry.
It's gonna be that kind of day, isn't it?
People online.
And just that quick, he's done. Okie dokie. Let's go back to Judge McNally.
Can't hear you. You been at work for the last year and 3 weeks? Well, maybe you got a lot of money to post a bond then. That's good. Does he stand mute, wait formal reading?
That's correct, Your Honor.
You still live on Bellet Terry?
No.
I need your new address.
13585 Avenue.
Hang on, 13585 Wilmont?
Yeah, Wilmont Avenue.
Hang on, slow down. Wilmont?
WOODMONT.
Woodmont.
48227.
Slow down. We got to get a hold of that lawyer. Ms. Holloway, I'd like to talk to you and the lawyer on the jury. Can we go, I'm gonna have to go in there. 13585 Woodmont, Detroit,
Yes.
48226,
7.
48227, 48227. What made you come in here today?
Started school in Pennsylvania.
You what?
I just started school in Pennsylvania. And they had let me know that I had money. I didn't know I had
Where are you gonna start your school then?
master degree service.
Are you going back to Pennsylvania?
I'm supposed to be after. Well, Latin Quarter.
With permission from
I-
the son.
I understand. $1,000 personal bond, you can leave the state without consent. You cannot violate a law. You must appear in court as directed. I'll let you appear on Zoom. What do you want me to do, Lisa? You want me to do the 20, let's see, today's the 20. Are you gonna be in town tomorrow?
I'll probably go back to study.
All right, let's just do the pretrial August the 6th at 8:45, okay? And you can appear by Zoom. All right, you can appear by Zoom.
Okay.
Now, you're going to school, but you gave me a Detroit address. We need to make you straighten that out with them down the hall, okay? So you make sure that you straighten that out, go down, get your notice. If you want a court-appointed lawyer, you can fill out a petition for one, okay? Thank you.
Thank you.
Thanks a lot.
Have a good morning.
You too, thank you.
Thanks.
Weisenstein,
Yes.
William Frank Weisenstein, 25W, 723254. All right, how you doing?
Not too good.
Pardon?
I thought you asked me how I was doing.
Yeah, and you said not too good?
No,
Why?
I'm sick right now.
Oh, geez, I'm sorry.
Thank you.
You did everything you're supposed to do here.
Yes, I did. I complied with all that. I had it done by last December.
Good. Raise your right hand. Solemnly swear affirm under penalties of perjury that the testimony you give in these proceedings will be the whole true self you got. You do?
Yes.
Okay, since you were in court on November 14 to 25, have you been arrested for any reason?
No, on the 14th, last Tuesday, my brother had passed away. His funeral was on the same day. So I came in and talked to Jessica O'Donnell, my PO, and she postponed it 1 week until today.
No, I know, but I'm just asking you, since you were sentenced, have you been arrested by anybody? Any other charges pending other than this one?
Nothing.
Congratulations. I'm sorry about your brother. Case dismissed. I wish you well.
Thank you, I appreciate it.
Good luck to you.
Can I ask you one question?
Sure.
Does this mean I'm allowed to go back home now?
Yeah, we're gonna cancel all the bond conditions. Who was this, who was the victim on this?
My wife, Cassie Weisenstein.
Yeah, I mean, the case is over. So Lisa, let's just make sure we cancel all those, take everything out of lien, okay? The no contact provision will come out, okay? Don't just show up on the door though. Why don't you call her, all right?
Yes, I would love to apologize to her.
All right, good luck to you. Thank you. Good luck.
Thanks.
Do you want to go call?
Yeah, I'm gonna have to go call. Do you have a case ready, Ms. Gurian?
Yes, Judge.
What-
Dimash Inc. D like dog,
I got it
E
right
M
here.
H.
Alrighty, friends, we're going to switch courts here in just a second. But before we do, Gigi, $5 donation over at courtroomfiles.com says for the best YouTube channel to date. Thank you, Gigi. I appreciate that very much. Let's go to Florida. First appearances, but it is not Wade Mercer. It is Judge Anna Garcia this morning.
Thomas, good morning.
Good morning. How you doing?
I'm well, sir. Mr. Thomas, tell me your full name for the record.
Trillian Kamarion Thomas.
Thank you. Does Mr. Thomas have any family members present here in the courtroom? Trillian, you have 3 people here for you. Tell me who you are and I'll tell him. Your sister's here? Your daddy's here? And your first cousin are here, okay? And they're here on your behalf. Trillian, you've been charged with 1 count of no valid DL. Mr. Mitchell, that's a
This is a second-degree misdemeanor.
second-degree misdemeanor, sir, punishable by up to 60 days in jail and/or a $500 fine. I do find that there is sufficient probable cause for that charge. Mr. McDaniel, have you had an opportunity to speak to Mr. Thomas regarding the offer the state has made?
I have, Your Honor. Mr. Thomas is going to plead no contest to the charge with the understanding that he'll pay $400 fine within 60 days, or he'll serve 10 days in the county jail. If he gets a valid license within 60 days prior to paying the fine, and given that license is perfect court, the fine would be $300. He has signed his plea waiver form, waiving his right to jury trial and call witnesses.
All right, and that's the agreement with the state?
It is, Your Honor.
Dad, sister, and cousin, do you guys understand what's happening? Okay, and do you have any questions? I know this is a young man. And do you have any questions for his attorney before he makes the decision whether or not to do this? You guys okay with it? All right. All right. So Trillian, did you hear what your attorney just said?
Yes, ma'am.
If you will, please raise your right hand, sir. I know it's hard. Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Excellent. You can put your hand down. Trillian, is what Mr. McDaniel said what you want to do?
Yes, ma'am.
Has anyone promised you anything different to get you to do this?
No, ma'am.
Is anyone threatening you?
No, ma'am.
Then I sentence you as he has just indicated. Trillian, if you get your license, that brings your fine down to $300 instead of $400. But I need you to understand, I know you've not been in trouble before. I need you to understand how serious this is. If the fine is not paid within the 60 days, then you are going to have to go to jail for 10, okay? And I don't want that for you, so I want you to take it very, very seriously. And call Mr. McDaniel if anything happens and you need extra time or whatnot. I don't know if Judge Mercer normally would give extra time or not. He'll tell you, but you got to speak, okay? And tell somebody something if you're in trouble.
There actually is a report date, Judge. If he doesn't have the fine paid within 60 days, he's to report back to the courtroom on September 23rd at 8:30, and the judge will make a decision based on what Mr. Thomas says.
Got it. So did you understand that there is a return date if the fine's not paid?
Yes, ma'am, I do.
Family, do you understand what's going on? Any questions? I don't want this to go any further for him. So I just want to make sure everyone's clear on what's got to happen. All right. Well, Trillian, good luck to you. All right.
Yes, ma'am.
All right. Excellent. Yeah.
Billy Crane.
Mr. Crane, good morning.
Good morning.
Mr. Crane, tell me your full name for the record.
Billy Ray Crane Jr.
Mr. Crane, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
All right, Mr. Crane, give me just 1 second. Mr. Crane, you've been charged with 1 count of attaching a tag not assigned. Mr. Mitchell, what level misdemeanor is that? Do you know?
It's a second degree misdemeanor.
Mr. Crane, that's a second degree misdemeanor, punishable by up to 60 days in jail and or $500 fine. I do find that there is sufficient probable cause for that charge. Mr. Crane, are you on probation anywhere?
No, ma'am.
Do you have any pending criminal charges, sir?
No, ma'am.
Has the state made an offer?
Yes, Your Honor.
All right, go ahead.
John, do you want to read it off?
Yeah, Your Honor, I spoke to Mr. Crane. At this point in time, he's going to plead no contest to the charges listed. You understanding he'll pay a $400 fine within 60 days, or he'll serve 10 days in the county jail. He has signed his plea waiver form, waiving his right to jury trial and call witnesses.
All right, Mr. Crane, if you will, raise your right hand. Sir, do you solemnly swear or affirm that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Sir, did you hear what Mr. McDaniel just announced about you pleading no contest?
Yes, ma'am.
Oh, you can put your hand down, sir. Is that how you wish to proceed?
Yes, ma'am.
Has anyone promised you anything other than what he just announced to get you to do this?
No, ma'am.
Is anyone threatening you?
No, ma'am.
All right, Mr. Crane, then I'm going to sentence you as Mr. McDaniel has just announced. Does Mr. Crane have family members in the audience? Who are you guys here for? Okay, he's coming up next. And so I'm going to sentence you, Mr. Crane, as Mr. McDaniel has just announced. Do you have any questions?
No, ma'am.
Sir, if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. Good luck to you, sir.
Yes, ma'am.
Timothy Summerlin.
Mr. Summerlin, good morning.
Good morning, ma'am.
Mr. Summerlin, tell me your full name for the record.
Timothy Floyd Summerlin.
All right, Mr. Summerlin, you have family members or friends here in the audience. Can you tell me your relationship? Your mom and your fiance are here in the courtroom on your behalf, Mr. Summerlin, okay?
Yes, ma'am.
Mr. Summerlin, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
Excellent. Mr. Summerlin, you have been charged with 1 count of grand theft. In case number 26 CF 391, Judge Mercer has already made a probable cause determination when he issued the warrant. Mr. Summerlin, are you on probation anywhere?
No, ma'am.
Do you have any pending criminal charges?
Not I'm aware of.
What about the ones in Calhoun County? Oh, no,
yeah,
I'm sorry.
That's right. I got pulled over in February, and they set me a court date for April, April, and I've been going to every court day. I'm not on bond or nothing. I just got to continue to show up for court, and like this, I show them every month that I'm paying a fine, and I got one more fine to pay, and that'll be this month, and then they're gonna drop it. That's who transported me over here.
So wait, who transferred you over?
Calhoun County, when they transferred me over here, they said I don't have no hold or nothing, that I should be able to bond out over here and continue to go to court over there.
All right, so your Bay County probation, you're no longer on probation in Bay County?
No, ma'am, I'm not on probation nowhere.
Looks like that DOP was resolved with the DOC sentence from what I was able to see.
Okay.
Yes,
All
ma'am,
right.
I went to DOC.
All right, Mr. Summerlin, I'm going to set your bond on the grand theft in the amount of $7,500. That will be cash or surety. If you make that bond, then I order you to have no contact with the victim. Are there any additional requests?
That victim is Walmart, so we would request no contact specifically with any Walmart.
Sure, no contact with any Walmart. Anything else?
Yes, ma'am.
All right,
Yes, ma'am.
Mr. McDaniel, do you have any anything further on this case?
Nothing else, Your Honor.
All right, Mr. Summerlin, if you get out of custody, then your next court date is, Madam Clerk, can you help me? Is August the 4th at 9 a.m. I want you to be before me in Jackson County, August the 4th at 9 a.m., okay?
All right. Yes, ma'am, thank you so much.
All right, thank you, thank you. Do you guys have any questions? Yes, so if you get a bondsman and they put up a bond, usually it's 10% and it would be about $750. It just depends on it depends on the deal that you come up with the bondsman. Okay. Now it is possible. Do what?
They just gave it up.
Yeah, well, I'm ordered no contact. Now, if he doesn't get out of custody and he stays until August the 4th, it is possible that the case can be resolved that day. We just don't know. All right. Good luck.
My pants too big, man.
Mr. McDaniel, who do you have with you?
Lucas, man.
Mr. Mann, good morning.
Good morning.
Mr. Mann, tell me your full name for the record.
Lucas Dwayne, man.
All right, Mr. Mann, you are currently, or let me ask you this. Did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
All right. Mr. Mann, the court is holding you at this time for Bay County. You have an alleged violation of your community control for the underlying charge of willful fleeing and attempting to elude. The judge there has already signed an, go ahead.
No.
Oh, okay. I thought that was you, John. The judge there has issued a no bond warrant, and therefore you're just going to be held until you answer to these charges in Bay County, and they'll probably transport you in the next day or two. Okay, sir?
Yes, ma'am.
All right. Good luck to you, sir.
James Hood.
All right.
Mr. Hood, good morning.
Good morning, ma'am.
Mr. Hood, tell me your full name for the record.
James Earl Hood.
Mr. Hood, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
All right, Mr. Hood, you are currently charged with 1 count of DUI and 1 refusal DUI. Both are kind of, well, the refusal is a first degree misdemeanor, punishable by up to a year in jail and or $1,000 fine. The DUI is a hybrid. It's a second. What's the max?
6 months. That refusal could also be a second degree misdemeanor if it's the first one.
It's a second.
If he had a prior refusal, then
it could be, okay.
But
all
it's
right.
still.
So it's the second offense or second degree misdemeanor, John?
It's a second degree misdemeanor. Second offense is a first degree misdemeanor. So his is a
Got
second.
it. Okay. So it's up to 60 days in jail, sir, for the refusal. And on the DUI, your maximum penalty is up to 6 months. Mr. Hood, are you on probation anywhere?
No, ma'am.
Do you have any pending criminal charges anywhere?
No, ma'am.
All right, give me 1 second.
Judge, he, local to the community, lives in Compass Lake, owns properties. He's got a, strong ties to the community. He, works in the oil industry here. Well, not here, but he works in the oil industry. He also has, very little criminal history. I think he has 1 boating incident about 5 years ago. That was, reckless boating that he pled to. And, we just asked for a reasonable bond.
Sure, let me say something. I have in 2021 DUI. It doesn't say BUI, but you think, oh, yep, ultimately it was pled to a BUI.
It was pled to a
That's all right. I think, yeah. So
pled
it's,
to a reckless boating. It wasn't a, but it was, it was, not a BUI. I mean, it was a reckless boating recklessly, but, was what it was pled to, Your Honor.
understood. Stacy, you were going to say something? No?
I saw the DUI in 21, but it was changed.
Sure. No, you're good. Let me look at something. All right, Mr. Hood, I do find there is sufficient probable cause for those charges. Stacey, we have the ability to test if someone's consumed alcohol within a certain period of time. So just no drugs or alcohol. Can we put them on Vivitrol and during the interim? How long will these cases take to resolve, or will it resolve in 45 days? Jake?
Sorry, Amanda texted me.
Yeah, I was talking to you.
Oh, can you say that one more
How
time?
long will it take for this case to resolve?
He's going to hire an
Resolve
attorney.
it by the arraignment.
Several months.
All right, so I won't do Vivitrol because it may resolve sooner than he can get the Vivitrol. But sir, I order you to not consume drugs or alcohol while you are on supervision. And you may be, while you're out on your bond, and I'll give you a bond in just a second. And you may be subject to random urinalysis and alcohol tests, even though the conditional or the office locally may not be able to. I think they can at, you know who can? CARE can. So I can send them to CARE to make sure. So you cannot consume a drop of alcohol while you are out on bond. I'm going to set your bond on the DUI in the amount of $5,000, on the refusal in the amount of $5,000. Total bonds will be $10,000. That will be cash or surety. And as a condition of those bonds, you may not consume any alcohol or drugs while you are out on bond. Okay? And you will be subject to random urinalysis at my direction or any officer's direction moving forward. Do you have any questions for me?
No, ma'am.
Okay. John, anything further?
Nothing else, Sean.
Okay, thank you. Leanne, oh, you need something? Yeah, do you guys normally? Okay, good, shoot. All right, Mr. Hood, I will see you on August the 31st at what time? At 9 a.m., okay?
Talk to your attorney. So
Yes, ma'am.
I'll get you another day, okay?
Okay, we'll see you then.
If he hires a private attorney, it'll be moved to the.
It'll be a different date, they'll explain it. All right. Who do you have now, John?
Your Honor, this is Leanne Tarbett.
Ms.
She has
Tarbett,
a,
good morning.
Good morning.
Go ahead, John.
She has a child support purge out of Clay County for $1,500.
All right, excellent. Ms. Tarbett, tell me your full name for the record.
Leanne Tarvett.
Ms. Tarbett, did you understand your rights that were explained to you on the first appearance video?
Yes, ma'am.
All right, Ms. Tarbett, as your attorney has indicated, you are held for child support writ of bodily attachment. That purge is $1,500. And if you wish to make that purge and are able to make that purge, then you may do so and be released from custody at any point in time. If you do not, then we will transport you to Clay County, okay?
Yes, ma'am.
All right, do you have any questions for me?
No.
All right, good luck to you, ma'am. John, does that take care of everybody that you have out there?
Yes, Your Honor, it does.
Anything further from the state?
Nothing from the state. Your
Okay.
Alrighty, friends. Good morning once again. TCF Live on this glorious Tuesday. It's good to have you all here with me. Thank you for taking your time to spend with me today. Let's go back up to Michigan. Check back in with Judge Oakley.
All right, airport, I'm ready for Mr. Brown, Daniel Brown. Airport, you're muted.
How about that? We're here.
All right, there we go. Mr. Brown, can you hear me all right?
Yes.
All right, Mr. Brown, I understand you have waived your right to have a court-appointed attorney for this arraignment?
Yes.
All right, so I've got two files. One from March 17, 26, one from March 27, 26. Both files have the same charge, trespassing. Trespassing is a misdemeanor. It is punishable by up to $500 fines plus court costs and up to 93 days in jail. Do you understand the charge, sir?
Yes, sir.
All right, and do you understand your rights?
Yes, sir.
You understand the options those rights present to you?
Yes.
All right. If you enter a not guilty plea, I can set you up with a court date to come back and talk to the prosecutor to see if there's a resolution on this case. You understand that option?
Yes, sir.
You're going to plead not guilty today?
Yep.
All right. Pretrial date for you is going to be my courtroom live, 9 a.m. on August 13th. Sir, I need your contact information for the file. I need to know where you're living or a good mailing address. If you're couch surfing or something like that, I need a mailing address. I've got in the file, I've got a 3rd Street in Detroit. Is that a good mailing address or is that an old one?
Yes.
Which one? Good address or an old address?
Good address.
All right. You got a phone number?
No, I had on a phone, but I had one on about it first.
I'm sorry, say that again?
I said, I don't have no phone, but I have one by the first.
Okay. I'm assuming if you don't have a phone, you probably do not have an email.
Oh, not really.
All right. When's the last time you had a job, Mr. Brown?
Oh, I'm on SSI, retirement.
Okay. Airport, it looks like he's got court dates already scheduled for August 13th. Including another trespassing charge. Do you have any information on when the incident date was on that trespass? If you know.
No, it was entered in June, so I'm not sure. When.
Okay. All right. Good morning.
Yes, it was.
Airport, there's something on the bond recommendation. There's a check mark in the felony category. But it says pending, and then I can't figure out what that says. Pending something for this agency. Can you clarify that?
I think it's the two.
That's resist and obstruct, isn't it? I think that's what that's supposed to mean. All right.
R&O, but I thought I was told by my lieutenant that we are not charging for the R&O.
Say that again. You're not charging with the R&O?
Yeah, that's what I was told.
Okay. So there are no pending charges other than the ones I've got in our court?
There's a pending trespass charge for today's instant.
Okay. All right. Mr. Brown, is there anything you want me to consider before I set your bond on these two files?
Oh, no, sir.
All right, Mr. Brown, on these files, on each of these files, I'm going to set your bond at 3,010%. That means you're going to have to come up with a total of $6,000, or excuse me, $600 to get released. You understand that?
Oh, yes, sir.
Good luck to you. I'll see you on August 13th. That's my courtroom.
Oh,
yeah. Your Honor, was that in person at 9 o'clock?
August 13th is live.
We don't want that one yet.
So that's what I'm looking for. This is what I'm looking for. Thank you, Airport.
Thank you.
Van Buren, I'm ready on Hollis. Or no, Van Buren, you got Hollis or Alexandra Brown? You're muted.
Unable to unmute, might be something that they can't do.
How can I unmute him?
We can't, but ask him if he can unmute, otherwise he might have to call back.
All right, Van Buren, I still show you're muted. Try to call us back. You there, Van Buren? All right, we got you. You got Mr. Brown there?
Mr. Hollis. I have Mr. Hollis on behalf of Belleville.
Hollis. All right, Mr. Hollis, I understand you have waived your right to have a court-appointed attorney represent you today for arraignment. Is that correct?
Yes.
All right, I've got 3 different files here. I gotta have Romulus and Belleville dates.
I don't think so.
Yes, you did. All right.
Good.
So first of all, I've got a December 7, 2024 Romulus drove while license suspended, revoked, or denied. Then I've got a Belleville March 29, 24 drove while license not valid or improper license. And then I've got a May 14, 24 drove while unlicensed or without cycle endorsement. Each of these is a misdemeanor. Each one is punishable by up to $500 fines plus court costs. Each one is up to 90 days in jail. Do you understand that?
Yes.
All right. Do you understand your rights and the options those rights give you today?
Yes.
How do you wish to plead to these charges?
CBT.
Your audio just cut out. How do you wish to plead to these charges? I'm not getting anything from Van Buren's audio.
Guilty, because at the moment my girl was driving me to work, back and forth to work, but since the vendor and the car was in my name, they put the tickets and stuff inside of my name.
Okay, so does that mean you're pleading not guilty to these charges? I'm still not getting an answer. I'm getting garbled audio.
Hey.
Van Buren, bring him in. I'm not going to play this game. I'll be here all morning.
Just wants to
Bring him in
know
here for
if you're pleading guilty or not guilty.
I'll plead guilty.
Can't hear. It's not the defendant's problem. It's your audio sucks.
Oh, okay.
Bring him in. What do you got, counsel?
Your Honor, I have the biggest case is Alexandra Sabo. She's calling in from Zoom.
Ma'am, how do you say your name?
Alexandra Sabo.
Sabo. Good morning. Counsel, your appearance.
For your Honor, Peter Honor, 78413. Am I using counsel for Ms. Sabo?
All right, she's going to plead to a no license on person?
She's going to plead to allow.
Okay, that's not what the paperwork says, though.
That's a problem. I'm sorry. I'll have to go back and that fix.
I mean, is that what the discussion was?
Well, the original charge was no license and we pled to allow it.
Okay.
What's up, Mr.
All right. Miss Sabo, hang with us. Who do you want to call next? Mr. Gibson, you there?
Peter Bernard, P78413, my niece counsel for Mr. Gibson.
All right, so he's going to plead to the charge as written. Is that correct?
Sure.
All right. Mr. Gibson, did you discuss your rights and options with counsel? You understand those rights and the options they present to you today? And you understand the possible penalty for this charge? Understanding that, you're going to plead guilty? Doing so freely and voluntarily? Counsel, the incident date I show is 2/26/26 in Romulus. Could you voir dire and get me the facts that support the plea?
Thank you, Mr. Gibson. On that date, were you at a Sheetz gas station in somewhere in the Vanguard Township or Romulus?
Romulus.
And at that time, did you have a confrontation, a complaint in this case? And is it true that you tapped your phone or put your phone onto her face? And isn't it also true that you made contact, your open or closed hand made contact with her face? Are you satisfied here?
Nope. At that time, was she pregnant?
Just the way that those things are. Another added wording.
So, I apologize.
It's not the way the complaint reads.
Is that one
Count one, domestic violence or knowingly assaulting a pregnant individual, second offense. So what's your factual basis for the plea that he's entering today? Okay, is this your second offense for domestic violence?
Your Honor, it's more of a notice. He has a prior conviction. I think the notice hasn't been given.
But it's charged as a domestic violence, knowingly assaulting pregnant individual, second offense notice. She's not pregnant and it's not a second offense. How is this a proper complaint? Absolutely.
Okay, I can probably vote here.
Good luck.
And sir, my name is Jacob. I'm the prosecutor in this case. I'm gonna ask you, were you sentenced in Colson County, Georgia, 6/30/2011? Florida. It was in Florida.
2011.
Yeah.
Not sure what year.
But you were sentenced in Florida to an assault and battery. Oh, there was assault and battery.
All right, I don't have time for this. You guys both have P numbers. Figure it out before you bring it back in front of me. This is a drastic waste of my time. What?
You have a set one up to go to.
Please. Rule?
Yeah.
Rule? Come on up. Counsel, your parents.
My mom has P87105, and that happens to Michael Rule, who stands to my left. Mr. Rule, please state your name.
Michael Rule.
Thank you. All right, so 2 new charges.
Yes, he's pleading to reduce now.
He's going to plead to a first offense, high BAC, right? And improper transport of firearm. Original counts 1 and 2 dismissed. You understand the possible penalty for those 2 new charges? Did you discuss your rights and options with counsel? Do you understand all that? Are you pleading guilty to the new charges freely and voluntarily today? Counsel, why don't you voir dire? Incident date from the Township of Huron on March 22, 22.
2022. On that day, were you in the area of 28823 Arthur Rock, Michigan? And that's in the county, Wayne.
Yes.
And in that area, were you driving a motor vehicle?
Yes.
Did you have you consumed alcohol prior to driving the vehicle?
Yes.
You would agree you had a BAC that was higher than 0.17.
Yes.
And you had a firearm in that vehicle.
Correct.
It was not unloaded.
Correct.
You did not have a CPM at that time.
Correct.
I'm satisfied if you are. Original counts 1 and 2 will be dismissed. I'm going to refer Mr. Rule down to our probation department to schedule a pre-sentence investigation interview. And counsel, you can pick a sentencing date. Anything else?
Could I just misdemeanor? Would it be okay to sentence him now or?
No, not for drunk driving. I have to have him screened. Yep. Bond is continued. How long do I need? You mean when will a sentencing date be scheduled? Work that out with probation. Whenever it works with your schedule is fine with me. You're welcome. What else is ready?
I got
Did Shemke talk to our arraignment?
I don't ask Whitney, but I don't see champagne anymore.
Yes, he talked to
Whitney, where
him.
we at?
He talked to him, but I don't know where he went, so I just emailed him to see if he's okay.
All right. Who's here on John Tez White?
All right, friends, I'll keep an eye on Judge Oakley. Hopefully his Tuesday stops being a Monday. Let's go down to Texas. We will check in with Judge West.
Powell. Good morning. And this is 25 DCCR 1522. Mr. Powell's charged with burglary of a habitation. And what is the announcement?
Yes, Your Honor, we received an offer this morning. I've relayed it to the client. I've also given that information to Mr. Galmore. We're just asking to be reset on another announcement.
Okay. It looks like Mr. Galmore just was hired in late June.
Very recent. Yes, Your Honor.
Okay. Any issues, Mr. Smith? Mr. Powell, I'm going to reset your case one more time. That'll give you plenty of time to go over everything with Mr. Galmore, Ms. Simmons, so that at that next court date, we'll see if we can get an announcement. All right, you can go back with the bailiff. Thank you, Ms. Simmons.
Thanks, sir.
That's it.
Hey, Luke, I didn't put a fine on that.
Good morning, Mr. Parker.
Oh, I'm so sorry.
How are you this morning?
Good, sorry, good.
I'm here.
All right, she's already taken a timeout. Let's go to Louisiana. We'll check in with the board.
Today with me on the panel is Mr. Tillis to my left, Ms. Stapleton to my right. My name is Pete Freeman. I will be the chair today with staff at headquarters. Please introduce yourself.
My name is Terrence Robeson.
Just hang on a second, bud.
Yes, sir.
You good, me? Sorry.
I'm good now? Yes. Okay, would you state your name and DLC number for the record?
Hi, my name is Terrence Robeson. I'm not sure my DLC number.
Okay, what about 706020?
Yes, sir, that's it.
What's your date of birth?
5/28/1995.
Okay, all right. Okay, we're here today, Mr. Robertson, for your revocation hearing. Did you get a parole questionnaire?
No, sir.
Okay, show him his questionnaire, please. Okay, you see that form? Is that your signature at the bottom?
Oh, yes, sir.
Okay, you realize you're not eligible for counsel. If you'd wanted counsel, you'd have to hire your own attorney.
Yes, sir.
Okay, you ready to proceed today without counsel?
Yes, sir.
Okay, your case was assigned to Mr. Tillis, so he'll be handling it.
Good morning. I'm going to read some violations that we have on you. You can answer guilty, not guilty, or with a statement.
Yes, sir.
Violation number 4, you were arrested by the East Baton Rouge Parish Sheriff's Office on the following offense: resisting an officer. It's an unlawful for any person knowingly or intentionally. Schedule 5, it is unlawful to knowingly, intentionally possess. Schedule 2, possession of a firearm, carrying a concealed weapon by a person convicted of a certain felony, obstruction of justice, illegally carrying a weapon, using weapon violently, drug paraphernalia, and unlawfully knowing, intentionally. Schedule 1. A hearing for a bond review on the matter was held on 3/10/26 on the 19th Judicial Court. Grant motion, and I relieve the accused of any bond obligations. However, the arrest is matter still in violation of your parole. East Baton Rouge Parish District Attorney's Office has of 5/14/26 officially billed the pending charges against the offender. How do you plead? Guilty, not guilty, or with a statement?
Not guilty.
You want to make a statement on that?
Sure. Um, I honestly was in the wrong place at the wrong time. I had no knowledge of no illegal activity or nothing illegal. I had nothing illegal in my possession. I didn't know anything was illegal going on where I was arrested at. I honestly was in a blind, was wrong place, wrong time.
Where were you? Where were you? The place you were at? Where were you?
A place I had went to with my ex-girlfriend. I was locked out of the place I was temporarily living at. I didn't have a key. I was just recently released 2 months prior to that.
That was your first time going there?
Yes, sir. I just called my ex-girlfriend for a ride until I can get inside. But I didn't have a key.
And my colleagues have any questions?
I do. Say it again. Now, was that your first time at that house?
Yes, sir.
You sure? Because they seen you at that house on several occasions.
No, sir. I don't be there.
They've been surveilling that house for a long time. And you can say with all the drugs and guns, you didn't know nothing that was going on in that house.
I honestly didn't, sir.
Okay.
I didn't see anything.
Ignore the commands of the officer.
Excuse me?
Why did you ignore the officer when he was giving you commands?
I was scared. I ain't never been through nothing like that before. I was scared. I was just trying to let my wife know that, hey, it look like I'm in trouble. I don't know what's going on. It's a lot of, I only seen stuff like that on the movie. I never experienced nothing like that in my life. So I was scared to,
Okay. I have no further questions, Carol.
I'm reading the same police report that the place had been under surveillance and that a person had gone upstairs and flushed down drugs in the toilet, and that you had been seen there before, and that you're not supposed to be anywhere where there is illegal activity taking place. That's your business to know this stuff. I will not associate with people who are known to be involved in criminal activity. So that's all.
Yeah, that's what I'm coming. She finished.
Yeah, she got it.
Okay, violation number 5. You were arrested by the East Baton Rouge Parish Sheriff's Office on the following offense: possession of a firearm or carrying a concealed weapon by a person convicted of a certain felony. How do you plead? Guilty, not guilty, or with a statement?
Guilty.
Not guilty?
Yes, sir.
Okay, did you have a firearm with you?
No, sir.
Well, tell us about it. How did the firearm come up?
I don't know, sir. I mean, I wasn't the only one at that place. So everyone that was there basically was charged with all the same charges.
And that was your first time, you say, going there, or you want to correct that?
Yes, sir. Me personally, I was just released from workforce, East Baton Rouge workforce 2 months prior to that.
And you never.
The police report makes it like I was a part of that investigation. Like I wasn't a part of that investigation. I just was caught there. I just was there, wrong place, wrong time, and it's like I'm in the middle of an investigation with that whole little case, but I had nothing to do with it. I just got charged with everything, just like the rest of the people that got charged with everything.
Okay. Rule number 10. You are in the arrear with parole supervision fee in the amount of $441. There has been a no payment record. How do you plead? Guilty, not guilty?
Payments,
Yes.
guilty.
Okay, colleagues have any questions?
Oh, I have no further questions.
Ready to vote?
Okay, we have the officer here, Mr. Taylor. Mr. Taylor, is there anything you want to say?
Yes, good morning, everyone. I was reviewing the last hearing regarding Mr. Roberson with the parole board, and I was reviewing the parole revocation decision. There was a remark that was made during that time pending the disposition of charges, which are the charges that were just read regarding Mr. Roberson, and an approved interstate compact to Texas. And so I was reviewing through the hearing that date, and I don't know if maybe it was overlooked regarding these charges, and I wanted to come back just to elaborate a little bit more before the parole board in the event it was an oversight. If it was not an oversight, then I stand corrected. The pending charges regarding Mr. Roberson from the East Baton Rouge Parish Sheriff's Office and the Baton Rouge District Attorney's Office on March the 10th of this year regarding those hearings, there was an oral 701 motion that was granted by the court regarding the billing of these charges by the DA's office. My understanding is the DA's office has approximately 60 days to officially bill an individual or indict an individual on new charges. In this case, because the DA's office failed to, either regarding probable cause or whatever the issue may have been, the court granted the 701 motion, which relieves the accused of any bond obligation in this case. So regarding the pending disposition at this time, the DA does have a time frame in which they can come and possibly bill Mr. Roberson regarding these charges. However, we do not have a date set if that will even happen. So right now, there is nothing pending further on these particular charges.
Thank you.
You're welcome.
Okay. Do you vote in executive session? What you want?
Let's go into executive session.
I have a motion for executive session. I have a second.
Yes.
Okay. I have a motion and a second. We're going into executive session. Would you call the roll?
Stapleton,
Yes.
Timmons,
Yes.
Freeman.
Yes, we'll be gone for about 2 or 3 minutes to discuss confidential matters.
Yes, sir.
All right, well, this is perfect. Well, they're in executive session. Let's go up to Alaska and look at the bears, because I'm currently counting 6 or 7 of them. They're having quite the breakfast meeting. So let's enjoy the bears for a minute. Alrighty, friends. Bears having been enjoyed for a moment, the board is back.
Vote today is going to be revoked for rule number 4.
Ms. Garland?
And I concur with Mr. Tillis, revoke, rule number.
And I found the same, condition number 4 and 10. I think you knew there was drugs in that house. If you didn't, you wasn't looking around your environment too well. So can't hang around with those kind of people. Today, your parole's been revoked. Good luck to you.
There you go, my friends. In hour number 2 of TCF Live on this lovely Tuesday. Good to have you here. Lone Wolf, good morning to you. If you're not familiar with Lone Wolf's channel, go check it out. He runs in the evenings. Barbara just dropped a link to that, so do give him your love. Look, all of us, especially in this LawTube space, we're all battling a lot of AI garbage. So if you find creators that you like, support them every way you can, especially if they're human beings. It do make a difference. Let's go to Texas Judge Stevens. This might be mid-hearing. He was muted for part of it, but I'm still curious because I've been there for a while. So let's see what's going on.
Before I actually went to court as well.
Okay, but it was in your system when you were in court.
Yes.
Okay. And then another thing I just mentioned in court earlier, but let's get some more testimony about this. During this time period, you were cleaning hotel rooms. Is that correct?
Correct.
That was your part of your job, correct?
Yes.
Okay. And there was a period of time that you were in rooms that you believed did have marijuana in it, correct?
Correct.
Okay. Were you using the marijuana?
No, sir.
Okay. Were you around what you thought or believed to be marijuana?
I wasn't around it, so that's why I'm not understanding why is he.
Well, I'm saying in the rooms, not people smoking, but in the rooms that people had been smoking in the rooms.
And when I proceeded in the room, I'll leave out and let my manager know that I would be able to do the work because I have a drug.
Okay. That's what I'm saying. Since then, that's what you've been doing. You've been telling it if you go into a room that you smell marijuana, you've been telling your manager, I'm not cleaning that room.
Yes, sir.
Oh, I'm sorry. So
Slow down.
I'm sorry. So since then, you've been telling your manager if you go into a room that you smell marijuana, that you can't be in that room, correct?
Correct.
Okay. And you recently got another drug patch came back in.
Yes, sir.
And it was clean.
Yes, sir.
Okay. So you believe that the marijuana that was in your system from the first drug patch was carryover from when you were using before,
Yes, sir.
or something to do with being in the rooms?
In the rooms.
How do you know that?
Because it was.
Are you clairvoyant? Or did you do a scientific test or anything? How do you know that's what's causing it?
Because when I proceeded in the room, it was smoked out.
All right. This is the second time you tested positive, right?
Yes, sir.
Okay, where are you getting your drugs from?
I don't do drugs.
You tested positive twice.
I think she means she doesn't do them now. She stopped.
You tested positive twice. Where were you getting the drugs from? You're not about to give up a source, are you? Keep going. Keep going.
Okay. Well, when did you stop smoking marijuana?
I stopped smoking in March.
Okay. All right.
But go ahead.
Okay. So you stopped smoking in March.
Yes.
Okay. And you're telling the court your testimony, for what it's worth, is that you haven't smoked any since March. Okay. When you came in here to court that time, it wasn't your system, right?
Yes, sir.
Okay. And you tested positive, and
I've been clean ever since.
And you took responsibility for that. Agreed. That was part of it. Okay. All right.
Wait, hold on. You tested positive for the drug test May, which was after that first one.
I think.
Why aren't you
Still working in a hotel?
Why aren't you being held? Why aren't you being held accountable for that? Because it's somebody else's?
No, sir. That's when I was working in the hotel room.
Okay. All right. Can you imagine? That's all anybody has to say. I walked past the hotel room and smelled marijuana. I'm going to test positive, and that's going to. You know what? You just interrupted the court, which is the rules really don't apply to you, do they? No, they don't, because you interrupt people when they're trying to speak, and that's not. We learned that when we were in the first grade. That was inappropriate, but it doesn't take us long to know that being around drugs is can hold you accountable. You have a responsibility to stay away from it, and I would be maybe getting a different job if it's because the people in the rooms are smoking marijuana. And let me ask you this, what hotel is it you work with that's so liberal in their rules where they let people use drugs? What hotel?
Hampton Inn.
Hampton Inn?
Yes, sir.
Okay, have you told the owners about, oh, there's too much drugs here?
I immediately told the manager right away.
Uh-huh. And are they here today to testify?
No, sir.
Why not?
I just was retained recently. This is a hearing came up. If you'd like to reset it for about
Yeah, I did. No, I'm going to make findings, but we can always hold another hearing.
That's fine.
And I'd like to know what actions that they might be taking to prevent her story from happening. It just doesn't make any sense, but I can't imagine the owners and the managers of the hotel just are flippant about it and say, we don't care. And our employees are put in harm's way and we don't care. I don't think that's going to be the story, but I know this is the second time you've tested positive, and that's 2 times too many.
If I may, Your Honor, just a couple of follow-up questions.
Go ahead.
Ms. Hill, you indicated or testified to the court that you stopped using marijuana back in March of this year. So your testimony would be back in November of 2025, you were using marijuana or a regular user of marijuana. So that would mean that
you have to speak up. She can't hear you when you mumble. You got to speak up. You're mumbling.
So that would mean back in November 2025, you were a regular user of marijuana, correct?
Correct.
And that would mean that back in November of 2025, when the Beaumont Police Department encountered you in the parking lot of that HEB, and they allege you nearly ran over 2 pedestrians, it was likely that you were using or on or under the effects of marijuana at the time, correct?
Yes, sir.
That's all the questions I have, Judge.
Did you say yes?
That's all the questions I have, Judge.
Okay.
No further, Your Honor, just arguments.
Anything else?
More questions?
Go ahead.
Your Honor, this is a situation where my client was a marijuana user. Came here for court way before I was involved. Tested positive. So it did what the court does in the situations, doubled the bond, gave her a drug patch. She got out. Her first drug patch did come back dirty, whether that was residual from carrying over from that before, depending on how heavy.
Or using or misusing drugs.
Oh, I was getting to those. Or if it was from the hotel or from using, we don't know, but there's a legitimate arguments there. If the second drug patch would have came back dirty, then there would be no arguments at all. Okay, there'd be absolutely 0 arguments I can make, and I wouldn't be standing here doing that. But the second one did come back clean, so she has stopped using.
Wait. How are you saying that second one absolves her of the positive in the first one? Come on.
It's saying that if she
what science are you using?
If she was a heavy drug user, Your Honor, at the time, and it was built up in her system, it would take some time to get out of the system. But now it is clean, and we see it clean. If the court wants to test her, by a live UA right now, then I'm sure it's going to show it's going to be clean, and that's going to be.
Well, we're not going to test people because they choose a time when they want to be tested. That's why we put a drug patch, and that's unfortunately she had a drug patch on this one and tested positive while wearing the drug patch. This is the second time. She's going to be held accountable. But as you always do, you have good points. But if it were me, I smell marijuana, I run like the wind. If I had things to lose like you do, or get another job where you're not around it, but you make the choices. And if you're going to be around it and you're going to say it's their fault, I'm sorry, you're going to have a problem proving that, because when it's in your system, if anybody could say without any other proof and substance that backs them up, it's just your word that I smelled marijuana. So thus I'm going to use the Tierra Hill rule. And once you smell marijuana, it must be that marijuana in my system that's tested positive, and that negates any allegation that the drug patch is showing misuse. And that's not the way it is. It's not a get out of jail free card. And here's the thing about marijuana. It's not like many other drugs. Marijuana gives you an advance warning. You can smell it from a long way off and you run like the wind. You don't go to the marijuana. You go stay away from it and you have a lot to lose. But I'm going to rely on the scientific test that caught you a second time.
I think that's
Anything else you want to add?
Yeah, exactly. I think you made one of my points for me there, Your Honor, that if you understand that going to a place that has marijuana is going to cause your drug test to be bad, that you stop doing that. And that's what's happened since that she's actually done that. She's done exactly what you said. That if I had something to lose, I would do this, and that's what she's doing now.
No. She smelled the marijuana and yet she went to the room.
I don't think she understood that it would cause any kind of test or problems. But after the first time, she understood it did and stopped doing that. And so now she doesn't do that. And the test shows that. It backs up that story.
This is the second exam. She's tested positive again. And we're going to help. It's double. Her bond is revoked. A warrant. You're taken into custody. It's a $16,000 bond. It's now $32,000. Plus, you must continue to have the drug patch as a condition of bond. What else are we going to do today? Is that
That's all I
it?
said today, Your Honor.
That's all I have, Judge.
All right. That is all.
So she says that being in a room with marijuana smoke is why she was testing positive with her drug patch. Do we believe her? Let me know in the chat. Let's go across the hallway. Judge West.
Morning, sir. Are you Kevin Thomas?
Yes.
And this is 26 DCCR 0798. Mr. Thomas is charged with assault on a security officer. Mr. Wilkerson, what is the announcement?
Your Honor, Mr. Thomas would like to proceed to trial on his case based on the underlying facts of the incident. I anticipate filing a notice of affirmative defense. And so I will get that filed. I've also got a HIPAA release that Mr. Thomas has signed. I do need to some time for those subpoenas to come back. So
there was already a plea bargain rejection. It looks like that was signed June 16th, the rejection of 15 years. Any change in that offer?
Yes, Judge, I have inherited this case from Mr. Coleman. I put a note to myself, see if Mr. Wilkerson and I speak in lieu of some notes that Mr. Coleman left before he switched courts. Before he maybe jumps through all of those hoops with those subpoenas. I understand where he's going. I think I'm probably going the same direction. Maybe one more setting before we were to place it on the trial docket. Let him get those in the works.
Sure, let's do
might be
that.
Productive.
Get with Ms. Malfino now that she's on that case, see if there's any new negotiations. Go over that with Mr. Thomas, and we'll, if it needs to be on a trial, we'll put it on at the next court date.
yeah, Your Honor.
Okay? All right, you go back with the bailiff. Then you got Javian Blunt.
Yes.
Javian Blunt.
Good morning. Are you Javion Blunt? And this is cause number 26, DCCR 1220. Mr. Blunt is charged with murder in that case. Mr. Wilkerson has filed a motion asking that I reduce the bond, which is currently set at $1.5 million. And Mr. Wilkerson, you may proceed.
Yes, Your Honor. This case, Mr. Blunt has been incarcerated now since March. And with regard to his case, we are still missing evidence in terms of whether or not well, let me put it this way: the person named in the indictment is apparently an alias of the actual victim, and so The concern at this point is, in part, a primary concern is whether or not the state could sustain a conviction as the indictment is presently worded. That being said, Judge, a $1.5 million bond does not meaningfully give Mr. Blunt the opportunity to secure bail in this case. And so, in being reasonable with the bond reduction request, given the standard bonds for offenses of this nature, we believe a bond of $750,000 would adequately secure the defendant's appearance in court.
I need some, Mr. Blunt, raise your right hand, please, the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes,
all right.
Mr. Blunt, state your name for the record, please.
Jain Blunt.
You presently working?
No.
Oh, well, obviously you are presently incarcerated in Jefferson County Jail, correct? Are you able to raise funds either by borrowing or disposing of assets to make bond in the present amount of $1.5 million? Do you believe that with the help of family and potentially friends, if the court were to reduce bail in this case, that possibility might be enhanced?
Yes, sir.
Can you describe to the court your familiarity with the area? That is, do you have family here in Jefferson County?
Yes, sir.
Are you from this area?
Yes, sir.
And have you been in Jefferson County for the last 5 years?
Yes, sir. I'm in my life.
All your life? Ever moved away?
Speak up, please.
No, sir.
Okay. Prior to becoming incarcerated, were you working?
Not right before, I was just not working in the Ford Arena.
Okay. How long had you been there?
A few months.
Okay. Are you asking this court in the interest of justice to reduce your bond from the $1.5 million that is presently set at?
Yes, sir.
Pass the witness, Sherman.
No questions, excuse.
All right, any other witnesses?
No, Your Honor.
Mr. Smith, any witnesses?
No, Judge.
What is the state's position?
State is opposed to a bond reduction, Judge. It's not uncommon that bonds in murder cases are set at $1 million.
I need you to speak up too.
It's not uncommon in this court and in Jefferson County that cases for murder with facts such as these are set at $1 million or greater.
So
Like that's a sufficient bond in this case.
do you want me to take judicial notice of anything?
The affidavit of probable cause would be.
Okay, I'll take judicial notice of the court's file, including the affidavit of probable cause. Give me just a second to get that. All right, anything else?
Nothing from the defense, Your Honor.
Also, the jail records show he has disrespect for the staff and other inmates in jail while he's been.
I'll take judicial notice of, I just received a jail incident report. Has two incident reports on it from July 15th and July 9th.
And I would just note, Your Honor, that both of them involve minor infractions. It looks like being out of bunk after lights out.
Right, this time I'm going to grant the motion to reduce the bond. I'm going to reduce the bond to $1 million. There will be bond conditions of house arrest, as well as wearing a GPS monitoring device if that bond is made. All right, you can go back with the bailiff.
Thank you, Your Honor. I believe that concludes my cases until the 11 a.m.
Thank you.
Excuse me.
Yes, sir.
Alrighty, friends. Good morning once again. TCF Live on this lovely, lovely Tuesday. Let's do this. Let's go back to Louisiana. This is at Lone Wolf's recommendation. He says this is a good hearing. I trust him. Let's see what's going on.
Sectional Center, my name is Pete Freeman. I am the chair. To my left is Mr. Tillis. To my right is Ms. Stapleton. With staff at the jail, please introduce yourself.
Yeah, this is Deputy Landry with the Jefferson Parish Sheriff's Office.
Okay, Deputy Landry, do you know anything about the prisoner? Any problems with him since y'all had him?
No, sir, I haven't. First time meeting him, haven't had a problem. No.
Thank you. Okay, and Mr. Alamos, please state your name and DOC number for the record.
Joshua Alleman, Alleman, DOC number 475639.
Okay. We're here today for your revocation hearing. Do you have a parole questionnaire with you?
Yes, sir, I do.
You realize you're not eligible for appointed counsel. If you wanted counsel, you'd have to hire them.
That's fine.
Okay, so you ready to go today?
Yes, sir.
Okay. All right, Mr. Alamo. It is alleged that you violated the following conditions. You can plead guilty, not guilty, with or without a statement, and we'll go through them as we go, okay?
Yes, sir.
First one, I will submit a monthly report by the 5th of every month until I complete my supervision. I will also report to my parole officer in order to do so. You failed to report to this office for an office visit since 3/13/2024. How do you plead to that charge?
Not guilty.
Okay, tell me what's your reason why you feel you're not guilty?
I mean, I was living at my brother's house and I notified the parole officer that I was living at my brother's and he was selling drugs and I just didn't want to be there. And I told him I was transferring to Jefferson Parish and he said he filed a transfer and never did.
Okay, all right, so I saw where y'all had sent some text messages. So, I mean, didn't you realize after you hadn't seen him for a while, you needed to get in touch with a parole officer?
I mean, I had called Jefferson Parish a couple of times and I mean, to no avail, they never came out and saw me.
Okay, because I mean, you're a fifth offender. You ought to know that you got to keep in touch with your parole officer or you're going to get in trouble. And I think I'd have went to the office if I'd been out that long and hadn't seen any officer. But I see where you did text on one occasion. But when they went to that residence, Jefferson turned it down. And then they couldn't locate you.
If you look at the case,
homeless or what, but they couldn't locate you.
They, I caught the new charge that they just dismissed. I was caught at that address. So, I mean, even 2 years later, I was still at the same address. I never moved, never left, never.
Okay, on or about, I will not engage in any criminal activity, nor will I associate with people who are known to be involved in criminal activity. I will avoid bars and casinos. I will refrain from illegal use of alcohol or drugs. On or about 5/4/26, you engaged in the criminal conduct, aggravated assault, and municipal or traffic attachment 3 counts, and you were arrested by the Jefferson Parish Sheriff's Office. How do you plead to that?
Not guilty.
Okay, tell me what happened.
All right, so this charge, if I may, this charge was caught way in October or December. I don't recall exactly which month it was, but my daughter was engaged in a relationship with a guy named Trey Gisclair. And he came to the residence where I was staying at 107 Riverside Drive and tried to force his way into the residence. I'm sitting there making t-shirts. I own a clothing brand. I'm sitting there making t-shirts and he tried to force his way into the residence. So I get up off the couch and I run him back out the house. Well, he's got military training in the Army. So of course I grab my razor knife and just, no, you're not welcome here. Get out of my house. And he called the police and said, I'm trying to kill him.
Okay, did you try to hold him there till the police got there?
Yes, I did. I tried to disable the vehicle. Yes.
Why did you, that's why you tried to slash the tire?
I cut one of the tires to stop him from getting away. Yes, sir. Because he has a history of strangulation. I met him in prison, and my kid met him behind my back, and got pregnant by him.
Okay.
And
All right. Okay, so there's been a little history between y'all two, in other words, then.
Yes, sir.
We can't be taking the law into our own hand. You're not a cop.
No. I mean, I wasn't trying to harm him. I was trying to stop him from getting away so they could get him. Because he had caused my daughter to have a miscarriage at 7 months.
Gotcha. All right. I will work at the job approved by my parole officer. If I become unemployed, I will immediately report to my parole officer. You fail to provide this officer any proof of employment. How do you plead to that charge?
I'm not guilty.
Okay.
I notified my parole officer the reason that I didn't have a job because I had neuropathy and I couldn't hold the welding rod. And I was working at Little Caesars, and he had notification of where I was working the whole time I was in Lafayette.
Okay. And what about your supervision fees?
I mean, I still have time. I never got back to work. I was trying to get this clothing thing off the ground for my kids. And
Gotcha.
I got caught up. I have a website and everything that I've been working on.
All right. We're going to speak to some people that are here to speak on your behalf. Melinda Foy, a friend.
Yes, sir.
Ms. Foy? And try to keep your comments to 3 to 5 minutes.
Good morning. Can you hear me?
Yes, ma'am. Tell me what you want us to know about your friend.
I want to start by saying that I understand that, Josh has a past, and I'm not here to excuse any mistakes that he's made, but I'm here to share the person that I know him to be today and the positive impact that he's had on the people around him. Josh is one of the most caring, hardworking, and genuine people I've had the privilege of knowing. He has a big heart, and he's the type of person who will stop whatever he's doing to help someone else. He's so kind, he's friendly, and he's someone that builds relationships with everyone he meets. But what stands out most to me about Josh is the love he has for his family. He has a deep love for his mom and his children. His daughters mean the world to him. And if you can see, based on his testimony today, how much they motivate him to live a better life. His children are a major part of who he is and who he wants to continue to become. I'm sorry, I'm out of breath. Josh is also extremely talented. He is good with working on cars, mechanics. He has an artistic skill, like his artwork is immaculate, it's something that I've never seen before. He truly has a gift that is unique. And all of the things that he do are dedicated to his children. I've seen so much growth in Josh. I see someone in him that wants peace, stability, and a better future. I don't see any troublemaking in him. He's someone that wants to be there for his family. He works hard, and I can see him moving forward. So I respectfully ask that you consider giving Josh the opportunity to continue to grow. There are people who love him deep, that depend on him and believe in him. And I believe that he can be a positive member of the community if he gets another chance.
All right, thank you, ma'am. Appreciate it. Teresa Mayfield, Miss Mayfield, you a friend?
Yes.
Okay,
I just wanted to break out what Mr. said. I've known Josh for almost 2 years, and as you can see behind me, I've purchased some of his artwork. I have a chef shirt that he made for me with some of his artwork on it. He's a very talented young man. He has taught me how to work on my children's cars, so it saves me a lot of money not to have to pay mechanic fees and shop fees. And he's come a long way in the 2 years that I've known him. And he's focused and driven on his art and his family and staying away from the people, places, and things that had construed him before and led him astray from the path that he wanted to be on. And I just want to say that he deserves an opportunity to flourish as he's begun to do. And I know he made mistakes. He didn't check in. He didn't make fines, but he's got people in his corner and his background that can help him financially and help him get to work and pay restitution so he can give back to society and give more to the community and his family with his artwork and his talents and his know-how on a lot of things. He knows a lot of things. Like he does construction work and stuff, and he doesn't mind teaching somebody how to do something for themselves with the knowledge that he has. So that's all I'd like to say. Thank you.
Thank you very much. Okay, Ms. Fran Alamo, your mother? You're on mute, Ms. Alamo. You're on mute, ma'am.
I don't think she's too familiar with Zoom, sir.
I'll help her, girls.
Yeah. I apologize. This is the first time I've used this Zoom
That's
thing.
fine.
Yes, I hear you laughing at me, son. All I want to say is I hope that y'all got my letter that I sent with the video. Josh has had our flag growing up with his father. Didn't have that connection, and so I've done my best. Excuse me. I've done my best to raise him and his sister, along with my mother. He just didn't have a lot of male help. He lost my father when he was 9, so in the later years, he just didn't have what he really truly needed. And so we did the best we could. He's a very hard worker. He's got a great heart. He is like Teresa and Mindy said, his artwork is just amazing. And recently he asked me to help him with this little website that he's been working on. I mean, I'm just amazed at what he's done with this website from the ground up. And I mean, it's just amazing. But he really wants, he's tired of that past life. He really wants to continue to better himself and stay clean. And like said, he has not gotten into any trouble at all. The assault charge, I don't even know how he got that, but it was dismissed. All he was trying to do was protect my granddaughter, his daughter, who at the time was expecting. And he's very well known and liked. He's got so many friends, I don't even know half these people. But he's never had any kind of physical attacks or anything on any other human being, especially women. But he's never been in a fight. The trouble he's been in the past was, unfortunately, was all due to drugs. But he's clean now. He's really been trying. He's been focusing with therapy, focusing on his art, and he will drop at the drop of I'm sorry, my words are at the drop of a pen. He will stop what he's doing to go help someone else. When he was younger, he was riding through Lafayette Park, and there was an elderly couple that had a flat tire. I didn't even know he knew how to do that, and he stopped and he helped them. And he's done that many times over the years.
Can you wrap it up now?
I'm sorry.
Can you go on and wrap it up, please, ma'am?
Yes. So anyway, the family loves him. We care. We're supporting him in his business that he wants to really get going. He wants to leave a legacy for his kids and his grandkids.
Thank you, Mom.
Thank you very much.
Thank you.
Okay, and I would like to always say, Mr. Alamo, you had Mr. Melvin Whining here. He's a friend. He was just here in support.
Yes.
Okay, I don't have any further questions. Do my colleagues have any?
Oh, yeah, Mr. Elliman.
Yes.
Why hadn't you got a job yet?
I have neuropathy. I had a head injury in 2008, and it causes my arm to go numb. When I was working at Little Caesars, I was making pizzas and throwing pizzas on accident. I didn't mean to. My hand would just let go. My arm goes numb. I was working at Bagwell Energy Services as a welder, and from holding the welding lead all day and TIG welding, it caused my arm to just fall numb. And I mean, I was messing a lot of welds up, and it was costing the company money. So I mean, I kept losing my work. So if you look at twistedcity504.com and you go to the about section, it explains to you my whole history. And my whole clothing brand that I've been working on for 15 years in prison. And when I got out, that's what I did with all the artwork that I've been doing for 15 years in prison, or 13 years in prison, was I implemented it and put it into the website. Or partially.
So that's what you're trying to do now with the t-shirt business?
Yes, well, it's not just a t-shirt business. I sell everything from shower curtains to tennis shoes. If you look at Miss Teresa Mayfield's back, that's a blanket. That's a blanket on the wall. I mean, I sell everything from home decor, and I mean, it's all custom, handmade, not handmade, but hand-drawn artwork.
Okay, what about drugs? Have you been involved in drugs lately?
No, sir, I've been clean. I was on Suboxone. I was on Suboxone when I got incarcerated, but I'm clean now.
When's the last time you had drugs?
Before I got incarcerated, I was on Suboxone.
Okay. I have more questions.
Well, I have a question. Your artwork is extraordinary. It's beautiful, and
Thank you very much.
I can't draw a stick figure and anybody recognize it.
Me either. I'd be embarrassed if I did.
But listen, like you were saying just now that you're selling all this stuff, but yet you're in arrears.
Well, I haven't begun selling the stuff. So it took me about 5.5 to 6 months to step by step learn how to build a website. And then once I started building the website, I got locked up. So I didn't have the chance to complete the website. And like, I sold literally one hoodie since I've been incarcerated. I mean, and I haven't sold much at all.
That was it. Thank you.
Okay.
Panel ready to vote. Okay, Mr. Alamo, the biggest problem is you can't take the law in your hand. You can't be going cut people's tires just to try to keep them around. And you're a fifth offender, you got to be in touch with your parole officer. I'll find you in violation of condition number 2, 3, and 4. And my vote is to revoke.
Okay.
Stapleton.
And I concur with Mr. Freeman. And I wish you every good fortune in the future and take his good advice.
And Mr. Tillers.
I'm going to concur. You really can't take the law in your own hands, but I hope that you will get your life together. That's my vote for today.
Good luck to you, sir.
Alrighty, friends. So sometimes when it rains, it pours, unfortunately. Let's take a look. This is the man's website. This is not a glitch in my browser. I tried it in 4 different browsers. This is what his website does. It's like, yeah, like stroke warning, or, if you're sensitive to this sort of thing. His stuff is cool, but his website is just completely broken. So it's no wonder that he said he's only sold one thing, and he probably sold it to a family member or somebody with an incredible amount of patience. Because his stuff is messed up, unfortunately. So I kind of feel double bad for the guy now. Not only is he incarcerated, his source of money, it's glitching out. All right, hour 3 of TCF Live. Let's get off of this stroke-inducing weirdness and go back to Judge Stevens.
We're David Noble. You have to speak up so she can hear you. Listen to what we're born. And you were charged with the state jail felony of unauthorized use of a motor vehicle, which carries with it up to 2 years in the state jail.
Oh. Did you not, how already get the document?
Okay, what are we doing today?
I've never met him before, Judge.
Well, that's David
He's-
Nobles right there.
He's on bond, so I'm gonna ask court for a reset to an announcement docket and I'll have a chance. to
What,
visit
does
with
he have a criminal history at all?
No history.
No, you've never.
It was a lie though.
Fix this. Work with him to fix this.
That's my ex-wife, I'm saying.
Okay, work with him to fix this, okay? You don't want a conviction, record that, if you do, that's just not logical. And a felony conviction follows you. It's like a gorilla on your back for the rest of your life. Fix it. And he knows how to fix problems, okay? All right, we're gonna give you some time, work on that. Announcement
dockets.
All right.
Just trying to reset and wait out.
Derek Robinson, you get a resetting from this lady and Derek Robinson.
I also called his name.
No answer in the courtroom. I asked the bailiff to call into the hall for Derek Robinson, 26 CR 67.
Judge, I have two active members for Derek Robinson.
Derek Robinson?
We may have a third one here in a minute.
Right. The first two.
Not on the next.
For stalking and.
Oh, these two cases.
Our response.
There's no response to the name called in the courtroom, no response to that name called into the hall. Defendant has failed to appear. What is his bond, please? He's got,
$1,000.
his bond is revoked. Warrant is issued for his arrest for failure to appear. It is 30, you said?
Correct.
It is doubled to $60,000 plus the defendant must have a GPS device and he is going to be at home confinement except for the reasons that we always allow, and that is just to leave to and from to his attorney in the direct route possible to and from court, and to and from job, and to and from hospital or medical care, and to and from food, acquisition of food, and the defendant must take the most direct route possible from his home at 2160 Radcliffe Road at Beaumont, according to the indictment. And this is a third-degree felony, but he's got a prior, it's assault family violence. He was convicted in 2018 for assault on a family member. And
There's nothing in the back.
in this court in 2017, he was convicted of assault involving family violence. This is his third case involving family violence with two prior family violence convictions.
Well, I used to deal with those cases, so,
Mr. Ham, you're the prosecutor on this?
I am, Judge.
Is there anything else you want to add? This is just, he's got two prior family assault convictions, and this is a third one that's been alleged. Anything else you want to add for any bond conditions?
I think you've done the most you can at this stage, Jeff.
Okay, then those are the orders of the court. Man, we hadn't seen something like that in a while. Herbert Smith.
Smith, Stephen.
26 CR 526. You're charged with operating a motor vehicle while intoxicated. And you have two or more prior DWI convictions. And you were going to have times the legal limit. And so this carries with it up to 10 years in prison. You probably know. You have an intoxilizer or an, is that yes?
Yes.
You have to speak up. All right. In your vehicle? Well, how do you use it?
I gotta blow it before I start.
It won't let you start unless you blow, right? Uh-huh. Have you failed any of those starts?
No, yeah.
Okay. What we're gonna do today?
Well, we had a previous offer for probation on the case, but I think after looking at the case now, Ms. Moore is refusing that offer. So
Is that right?
It was I initially offered prison time, and then I believe when we were in court, defense counsel gave me a counter. And I don't remember if I agreed to the counter or not, but then I went back to my office and looked at all of the priors because he has he has like five prior DWIs. I said no to probation. And so it is going to stick to that prison time offer.
5 priors?
He has some out of Louisiana also.
Oh,
everything's a misdemeanor. This is the first felony there's been, and we had requested a probation offer, which she gave me at that time, but now she's withdrawn the offer as of this morning. So unless she changes her mind on it, then I just need a normal reset for me to discuss with him what the other options would be.
Alrighty, looks like Judge muted himself. Let's see if we can bump past. We're a little bit in the Wayback Machine here. Alright, looks like you just moved on. Let's go across the hallway, Judge West.
Up there. I think I know what you can go with it.
It's not my.
DCCR 0082, you're charged with a first-degree felony offense of injury to a child from December 16th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them, but the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. DeLage? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Walker's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the offense of injury to a child. Sentence you in accordance with your agreement to a term of 22 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. DeLage. And Ms. DeLage, do you have your discovery certification?
The cert, I don't have the discovery sheet yet. I was going to email it this afternoon. Didn't expect to get a plea today.
Yeah, if you'll get that done as quickly as possible, and because the case has to get closed out, then it becomes, you won't be able to get to it.
Yes, ma'am.
Okay, you can go back with the bailiff.
Thank you.
Do you want to make these?
But that's what's alleged is that and how.
Thank you.
Thank you, Mia.
And I excused.
Yes, thank you.
Huh?
And Mr. Parker, you've got Gabriel Cruz.
Ma'am.
Good morning.
Gabriel Cruz.
And I've got 2
Sentences.
and a dismissal on one, is that right?
Sheriff, why did you let me do that?
He said, what'd you do? I said, I came over here, I know the judge on the page.
I knew you did. Mr.
I was thinking, yeah.
I mean, I thought about it.
I didn't even look.
Good progress for you.
I still think back to the day when the Boston Habitation looked in here on it.
Oh, yeah. Yeah. Good morning. Are you Gabriel Cruz III?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
0373 and 0374.
Mr. Cruz, in cause number 26 DCCR 0373, you're charged with a 3rd-degree felony offense of stalking from February 23rd of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
And then in cause number 26 DCCR 0374, you're charged with a 3rd-degree felony offense of violating a protective or bond order, and that's from February 23rd of 2026. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? I have here on the tablet in each of those cases some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreements that you've reached are for 10-year term in prison on each of these cases, but that would be probated for 10 years. There would be a $500 fine in each case. There would be a dismissal in cause number 26 DCCR 1060, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
State tenders number 1 in each case. It's admitted in each case. Is there any evidence that Mr. Cruz is not competent?
No, Your Honor.
And Mr. Cruz, do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State, sorry, we already did that. All right, I'm going to find, Mr. Cruz, that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your case for sentencing so that we can get a pre-sentence report that'll give me more information about you and your cases, and then we'll come back later for sentencing. All right, you can go back with the bailiff. Mark Hebert, Mr. Parker, it's a sentencing.
Yeah.
This crew was done.
I don't hear from this week. I thought it's probation officer, the kitchen. Ashley. You just not got it. Yes, but not.
Man that you were talking to behind me. Is that Mr. Celestine?
No, that's the father of Hakeem Dolls.
Okay. He lives over there. I was curious.
Good morning. Are you Mark Hebert?
Yes, ma'am.
And Mr. Hebert was previously in court and entered pleas of true to counts 1, 2, 3, 5, 6, 8, 9, and 10 in a motion to revoke his probation. He's on probation for driving while intoxicated third or more. This was unagreed. I've received the updated pre-sentence report. Have you both had an opportunity to review that report?
You have, Your Honor.
Judge. Any additions or corrections to the report?
None more, Judge.
Mr. Mr. Parker?
Judge, I mean, my intention, excuse me, was that, and what Ms. Malfina and I talked about is that he had some serious health conditions. He ended up using drugs. I don't know how long he had been using drugs in the past. He and I had a heart-to-heart talk, explaining the situation he's in, and we talked about Safe P being a great option for him. Now, his mind has changed, and I like to let him address the court, but he said being in jail, he's been in there for a while now. He said his mind's clear, and he was here before on oxygen, and he's able to breathe better with his emphysema and all the other issues that he's had. But he's indicated he just wants to take his time. And I mean, my position is that, I personally think Safe P is probably the best thing for him. But at the same time, if he doesn't want it and then why take him to bed? Ms. Bells could use it. I'd like to let him address the court, Judge.
So, Mr. Hebert, the recommendation was for potentially Safe P and to get you that help. Are you saying you don't want that?
I'd like to just go back to probation and get help from home.
Well, that's not going to happen.
That's okay.
Yeah, so it's either Safe P or prison.
Safe P. Yes, ma'am.
So here's the thing about Safe P. It's an expensive program. And I don't want you to, kind of like what Mr. Parker said, go just take up a bed and we pay $70,000, $80,000 for you to go and you don't get what you need out of it. If you don't go in with the right mindset, then it's going to be a waste of everyone's time. If you want that help, I'm willing to give it to you.
Yes, ma'am. Please.
Ms. Malfino?
And if I may respond to one other thing, I think part of his attitude was when he did the PSI is that he was like, I'm on drugs. And I think maybe now that he's been there, he's cleaned up a little bit and not on drugs and realized that the help, he really needs that. And
I mean, you tested positive 1 month after having an angioplasty and a stent. You started using drugs again. So obviously you need some help.
Yes, ma'am.
If you're doing that 1 month after that kind of scare. So
Yes, ma'am.
Ms. Malfino, anything to add?
No.
So, Mr. Hebert, I'm going to give you this opportunity, and I hope you take advantage of it. I'm going to find that you entered your pleas of true, freely and voluntarily, find all of those counts true, find sufficient evidence to revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. Let's see, you were put on in September 25. I'm going to order that as a condition of your probation, you enter and successfully complete the safety program. If there are still ongoing medical needs, then they'll put you in the special needs safe P to make sure that any of that's taken care of as well. So I'll let them determine which one, but it probably would be the special needs if you're still having some ongoing health issues. This is your opportunity to get clean, live the rest of your life, finish your probation, and not go to prison.
Appreciate it.
You're not going to get an opportunity like this again, so take advantage of it.
Yes, ma'am.
So this was not an agreement. So I'm going to hand you the trial court certification. You have some rights to appeal. Can't imagine that you would, since I just did what you asked me to do, but here is, if y'all will sign the bottom and then just give him the bottom. Brent Smith.
Thank you, Judge.
That one.
Yeah.
Good morning. Are you Brent Smith?
Yes.
And this is cause number 26 DCCR 0128. Mr. Smith was previously in court, entered a plea of guilty to burglary of a habitation. It was an agreement. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor. Yes, Judge.
Any additions or corrections?
None more, Judge. Not from the state.
So my concern here is the drug issue and the type of drug specifically with PCP, and I'm not real sure that I'm just considering potentially ISF for some treatment.
That was part of the recommendation.
I don't see that. I thought it was, I don't,
If ISF substance abuse, it was part of the.
okay, well, it's not on here, but that's what made sense to me, so,
Yes, ma'am. That was part of the deal. That was
Okay.
the only reason probation was offered in this case.
okay. Got it. All right, so Mr. Smith, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings, place you on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include entering and successfully completing the ISF Substance Abuse Track Program. And then once you're released from that, you'll be on the specialized mental health caseload and be required to follow all of the rules, all of the recommended treatment, including medication. Whether you feel like it's something you need or want, if they recommend it, it's going to be part of your probation that you have to follow all of those rules and recommendations. Do you understand? It looks like any other follow-up treatment from after ISF. And obviously you are to remain away from 4325 Galveston Street. You cannot be anywhere near that location. Do you understand? All right, I'm going to hand you the trial court certification. It shows this was an agreement that I followed and you waived your right to appeal. You're very lucky, sir. Because the house that you broke into, most houses that you break into nowadays, you could end up with someone taking care of that on their own, especially if you enter into a law enforcement officer's house and traumatize them and their family. So do you understand the seriousness of this? So if you do everything you're supposed to on this probation, this is a great opportunity. You don't have the conviction on your record. We're going to get you the help you need. You can be successful. But the other side of that is if you violate any condition of probation at all, You will be back here in court. You could be found guilty of the offense and sent to prison anywhere in the range of punishment, which is between 2 years and up to 20 years. Do you understand? All right, and go back with the bailiff.
Thank you, Judge.
Alrighty, friends, entering the final half hour of TCF Live for this Tuesday. Let's go up to Michigan, check in with Judge Middleton. He's been working all morning, but most of what he was doing was landlord-tenant, which we generally don't cover here. But it looks like he's moved on from that. So let's see what's going on.
2690. The defendant was on bond on a charge of indecent exposure, and Ms. Canfield filed a motion to increase his bond, and that was set for this morning. In the meantime, I had a question then. I was in on a day off, and I looked at this and I set it for this morning. Why not just do a new warrant for Mr. Barber for the alleged indecent exposure? So they did do a new warrant. The file number 261320FY is a felony charge, indecent exposure of a sexually delinquent person. So there is an open warrant for Mr. Barber's arrest on a new indecent exposure charge from July 6th, which was the basis for the motion to increase bond in the earlier case. So Ms. Ives is here and Abby Stoll is here. And we have the officer here too. We don't have Mr. Barber. Ms. Ives, have you had any contact with your client?
I have not. He did not appear for his attorney pre-trial conference on Friday morning on another matter.
All right, I'm going to do a bench warrant, Abby. No bond, see judge. No 48-hour hold. Defendant has new warrant. In file 261320. So I guess that's the best we can do on that. I don't know where he is, what he's doing, but he isn't here. Ms. Ives was already set to be here this morning for 2 other sentences, which is why this got set in there. Anyway, we have an open felony warrant and 1 or possibly 2 bench warrants. And he never got fingerprinted. All right, it's also the time for sentencing in Mr. Quincy Washington. Proceed with that one. These are both ordinance cases. This is file 26944OD, People versus Quincy LaShawn Washington. That's you, sir?
Yes, sir.
Here with your lawyer, Rhonda Ives. Also present is Daniel Frazine, who prepared the screening report in this matter, which I had a chance to read carefully yesterday. Ms. Ives has just given me a document from a Loom Wellness Group. and some AA 12-step laws. Ms. Ives, what would you like me to know?
Well, Your Honor, just a couple things. My client is 29 years old. His prior record dates back when he was a young teenager, or at least 18 years of age or younger when the other incidents happened. This is his first offense since kind of that, those situations that happened when he was a younger adult. We've read the recommendation. My client is working full-time in Sturgis, and it's a company that I'm not familiar with. What's the name of the company?
Harbinger Motors.
Harbinger Motors. So he works there full-time. He is hoping that the court would consider a suspended jail, but as well, perhaps there's a recommendation of a 2-year probation period. He was hoping that maybe the court might consider a 1-year probation period on this matter based on the history, his own lack of a serious criminal history, at least no record of any recent criminal history, and allow him to go on probation. Thank you. I would also indicate in the documents that I gave you, don't really want to make them public record. And I don't want to say too much on the public record because they do contain confidential health information, but he is in counseling and treatment. And I provided that letter for the court to review. There's also some AA attendance that he was attending as well. Thank you.
All right, the day started out pretty good, but he ended up at the new Old Hillcrest and all went downhill from there. Daniel, your recommendation is a probation, deferred jail, testing, and he's willing, I guess, to do a 12-month probation rather than 24.
Well, Your Honor, when I originally met with him, he hadn't done like the victim impact panel, but he was very open to this stuff. We had a really good conversation, and he asked me some questions, and I explained to him how the VIP works, some opportunities to do the VIP ahead of court, as well as the meetings and being engaged in services. He did everything. After speaking with me, he took it seriously and said, okay, I'll do it. So I would be okay with a 12-month probation. I just think with his past history, it did involve an accident, even though, I mean, a deer jumping out could have happened to anybody, but had he not been drinking, could he have avoided it? We'll never know the answer to that. So I'd be okay with the 12 months with the stuff that he's already done.
All right, I'm thinking about even doing a 6-month. The conviction was it impaired?
It should be impaired.
Yes, it is an impaired, Your Honor.
All right. Mr. Washington, what would you like me to know?
I would like you to know that I regret my decision and it's already took a toll on me and it would never happen again. And I mean, I'm willing to do whatever. I've been trying to go to meetings, get therapy, and do everything I have to so I can get on with my life and be better.
All right, I can accept all of that. I'm gonna do a 6-month probation. Which means you could be off this in just 90 days. You're doing much of what I've asked you to do.
Thank you.
This could theoretically be a serious misdemeanor because there was an accident, but there's a presumption unless that there is no additional jail or probation. But there was an accident. The blood alcohol was, PBT was 1.7. The tests were a little less. I'm glad you didn't kill yourself and read about it in the newspaper. I'm gonna do 3 days jail credit 1, leaving 2 days to serve, and of the 3 days, 2 are deferred. I got 2 days jail hanging over your head. There's a $300 fine, a $75 crime victims' rights fee, a $50 state minimum fee, $100 screening fee, $150 attorney.
Your Honor, can we cut that in half since we got that paperwork this
All
morning?
right, we'll make the screening fee 50. I'm impressed that you started out with a Loom Wellness Group on your own. I don't know whether you can drink or not. You can't drink during this probation or use any marijuana. But I think you can do that for 90 days, then you can decide what you want to do after that. I'm gonna order the victim impact panel, which you've already
already
done
did
it.
that.
All right.
Yeah,
I'll
you
just
completed
do-
the victim impact panel yesterday, I believe.
All right. $145 police reimbursement. Probation is $240. $300 plus $125 plus 50 screening fee, attorney fee of $150, $240 probation oversight fee, which could be reduced by half. It's $1,010. Substance abuse counseling and treatment as directed. No drugs and no alcohol, and test as directed. Are you going to continue with the loom?
Yes, Your Honor.
Very good. Is that the first time you ever done anything like that? I'll just say this, you get as much out of it as you put into it.
Yeah.
I think you're going into this with the intention to try to make things better, and I guess I'll respect that. But you're still here, and that's all right too. I suspect that you're gonna do what I asked you to do on this probation, and you'll be done after 3 months. If not, there's a couple days waiting for you, but I think you're gonna be all right. You go with Daniel and he'll get you.
Thank you, Your Honor.
All right, thank you, Your Honor.
All right. Now,
Alrighty, friends, let's head back down to Texas, check back in with Judge Stevens, new contestant there.
A third-degree felony of injury to an elderly person, is that right?
Yes, sir.
That carries with it up to 10 years in prison if convicted. Okay. Who is the victim in this case? What's the relationship?
Greg Broussard.
What's the relation?
I was a living caretaker. And yeah.
You were the caretaker for the person? Well, there's nothing funny about this.
No, I'm not laughing.
You were
I'm
the
not
caretaker for the person?
Yes, sir. I'm really.
Now, let's see. You're alleged intentionally and knowingly cause the injury to a person 65 years of age or older by pushing them to the ground, and you were being paid to take care of them?
I was living.
Is that right?
Yes, sir.
No.
Well, not paid. It was like a meth house. It was a horrible situation. We're living there. It was like a meth den. It was 3 years ago. I went to.
What were you doing in the meth house?
I got kicked out. What was I doing? I would took care of that. I'm so sorry. I wasn't really trying to get funny earlier. I apologize. I do things like take care of the house, wash the clothes, took care of him. When I moved in,
Were you getting paid for that?
not money, room and board, drugs, all that kind of stuff.
You were getting paid with drugs?
Yeah, drugs, room and board, food, stuff like that.
Who was paying you for, who was paying you with drugs?
The gentleman, Craig Broussard. It was a horrible situation. I went to rehab right after this incident. I completed rehab and I've been clean. So, so I apologize. I was, it makes light of the situation.
Mr. Broussard didn't put a gun to your head and order you to
No,
take
sir.
these drugs, right?
No, sir.
You made a free choice?
I made a free choice and
Mhm.
it's method's the devil, sir. And it's been, it was horrible.
When did you find out that it was the devil? I mean, I've
That-
heard,
that night
I've heard
was
of
a-
that when I was a child.
Yeah, that night was a big eye opener for me.
How old are you?
45.
You just figured this out, that methamphetamine is evil? Really, at your age?
A spiritual awakening.
Where have you been?
In the world. I apologize. I mean, yeah.
Well, it's out there in the world.
Yeah.
Aren't you reading the papers or something?
No, sir.
Oh, you're hiding under a rock somewhere?
No, sir.
Come on.
Yeah.
This is common knowledge.
Yes, sir.
All right. But anyway,
Yeah.
that still is not an excuse for committing a crime as alleged here, if this is true. Anybody 65 years of age or older is deemed elderly, which causes an enhancement of culpability for someone who injures them.
Right.
Let's see. Apparently,
Yeah.
he had a laceration to the back of his head. Do you have any prior convictions?
Drugs back in like 20 years.
Is that yes?
Yes, sir.
You mean?
Yes, you're on.
Okay, felonies. I'm talking about felonies.
Yes, you're on.
Where?
Harris County and Dallas County. I've been doing good up until, I didn't even, I'm not trying to go for guilt. I'm not going to go in guilty.
Look, hold on, sir. There's an old saying, what's in the past is never really in the past when it comes to prior convictions. You get punished for the circumstances of the crime if committed and criminal history. That's the equation that's used in federal court as well as state courts, including Texas courts. That's the equation. If you have prior criminal history, it's best not to get around a crime because it will be used to enhance the punishment. Anyway. All right. We're going to reset this for an announcement, Don.
Yes, sir.
Right?
Yes,
Good. Okay. And that gives the state some time to look into the criminal history. Yeah. How many, what are the felony convictions? The drugs?
In 98 was under grant, drugs. And the second one, I don't remember the year, was criminal mischief. I got drunk and ran into a house in Dallas.
That wasn't an excuse though, is it?
No, there's no excuses for anything like that.
Unless somebody slipped you a cookie or something.
No.
Okay.
There's no.
But are you sure those are two felonies?
Yes, sir.
And those were at separate times?
Yes, sir.
That's not good.
The criminal mischief judge is a state jail felony.
Okay, that's not going to be used to enhance.
Okay.
It has to be above a state jail, third degree or higher. Okay. But there is another one out there.
Yes, sir. No, yeah, in Harris County.
Is it a state jail felony too?
Jail.
Are you sure? The other one is a state jail?
Yeah, exactly. I got probation.
Okay.
Yeah.
Okay, well then,
then
that's not going to enhance the punishment if that's true.
What?
Okay, but if it's a conviction, it keeps you from getting probation in front of a jury because state jail felony conviction counts as inability to get probation from a jury. All right, but we're going to reset this. You and your lawyer can work on something.
Okay, thank you.
Give me a minute.
Here's setting on this for an announcement.
You can. So you shake? Okay.
Brandon LaFleur. And we've got Kiera here. Why?
It's signed up, Judge.
Okay. Brandon LaFleur. No answer in the court will. I ask the bailiff to please call into the hall for Brandon LaFleur. The defendant is charged with the third degree felony of injury to a child.
There you go.
All right, all good? I thank you.
By shoving and pushing the child out of a moving automobile. That's got to get people's attention.
Easier, non. That's the upside down picture. I'm on, we just said.
Okay. In 24 CR 2161, you were Brandon LaFleur?
Yes, yeah.
See, you were here before. You were charged with a third-degree felony of injury to a child. Have you hired another attorney? That's what.
No, I had applied for
What?
for the point lawyer.
Why? You're not employed?
Yeah,
Are
I'm
you employed?
Yes, I'm employed.
So why do the taxpayers pay for your mess? That's not right. I'm a taxpayer. I don't think much of that. You've been charged with a crime, just like anybody who has a mess. You're a grown-up. You got to fix it.
I understand that.
Not let 250,000 people pay for your mess.
I understand that.
It's not on my watch. That's not going to happen. Where do you work?
At M&P.
Okay, and how much do you make an hour?
1950.
Yeah, that's 20 grand. That's 50 grand in a year.
Well, Your Honor, I hired a lawyer, but I couldn't keep up with his pay.
Well, there are other lawyers out there who can work with you. You go out and hire. We were here before, looks like on June 11th. What is the defendant's bond, please, on this? Brandon LaFleur? Do you, the state now?
$15,000.
I'm looking at this probable cause affidavit. And this is about one of the most disturbing things I've seen in my career. Okay, you're charged with a third-degree felony of injury to a child, and it alleges that you intentionally and knowingly caused bodily injury to a child younger than 15 by shoving and pushing the child out of a moving automobile. So I go to the probable cause affidavit, and I don't think I've ever seen such a thing in my career. But you do this long enough and everything comes around, and I've handled about as many cases as any lawyer and judge my age, but I've never seen such a thing. So you're driving a vehicle, and apparently,
allegedly they're saying I was driving.
Did you interrupt me just then?
No.
Let me speak and you'll have a chance. I'm going to read what the probable cause affidavit that's filed in this record by the police that investigated. So apparently you had a paramour girl friend who had a child. I'm sorry, her granddaughter was in the car with you. While in the vehicle, you and the lady began to argue. It is alleged that you struck her in the face, causing pain and injury. You struck a lady. Who does that? That's so ungentlemanly. But you need to pick on people other than girls. Then that caused her to fall out of the vehicle, leaving the 1-year-old child in the passenger seat. Then, according to the lady who was thrown out of the car, you tossed the 1-year-old out of the car while you were driving the vehicle, causing the 1-year-old child to injure the child's face. Are you kidding me? You shoved a 1-year-old infant out of a moving car?
No, Your Honor.
No, that's what this says, and that's what the grand jury indicted you for. So the child's, okay, hold on, let's see. The child has facial injuries, and according to this, caused by what you did. Did the child rub her own face on the road? Is that your story?
I have no idea.
Well, the grand jury thinks otherwise, and the police that investigated it thinks otherwise. But I must say, I'm appalled. I can't imagine throwing a one out of the car in the first place. That's so ungentlemanly. But a 1-year-old infant, a helpless infant, tossing out of a moving vehicle, and then the child's face is injured? What's his bond?
$15,000.
It's $100,000. It is changed based upon the circumstances to $100,000. On this court's watch, you will not harm an infant, intentionally harm a 1-year-old infant and toss them out of a moving vehicle. The grand jury says that's what you did. You're presumed innocent. I wrote the lead article on that. That's blessed to me. But the grand jury says probable cause exists for that you did this. And based upon probable cause, that's how a case moved forward. Bonds are based on the charging instrument, probable cause, and criminal history. This is one of the most disturbing probable cause affidavits I have read in my career. And I'm going to treat you like I would treat anybody in the same circumstance. Somebody charged with throwing a 1-year-old out of a moving car and causing face injuries is going to be held strictly accountable on my watch. So your bond is $100,000.
But the
Plus,
affidavit is not true.
the affidavit is not true. So now you're saying the police committed perjury. Well, we can prove that. That can all be provable later. But right now, we're going to trust what the police officers stated under oath and what the witnesses stated. You'll be taken into custody. If you post your bond, you must be at home. I don't want you driving people around in your car. You're dangerous, especially to 1-year-olds. You must be on home confinement. You can have a GPS device and you can go to and from work, to and in the most direct route possible, to and from food, to and from your lawyer that you may hire or who's ever going to represent you, and to and from court in the most direct route possible. Those are the normal orders the court gives when somebody's placed on home confinement. But anyone charged with throwing a 1-year-old out of a moving car is frighteningly a threat to everybody's well-being. That's the orders of this court. And the next event, do you have a lawyer at all representing?
No, Your Honor.
Okay. Okay. If you're unable to hire one because of what the orders of the court, fill out an indigent form and I can get somebody to represent you immediately.
Your Honor, I did fill out one the last time I was here.
Who was appointed?
Nobody contacted me. I even told my bills bond I was not contacted. They said they'll make a note.
Where would the indigent form be that he filled out earlier?
Judge, I'm unsure if it's not in the file, when he's arraigned at the jail.
Where did you fill it out at?
Next door.
Oh,
it wasn't in there.
okay. That's,
Yeah.
God knows where it is
Yeah.
now.
Judge,
You could fill out another one right now, before you leave, before we take out, fill out, then I'll get somebody.
He has a
appointed.
misdemeanor case with him.
Sir?
He has a misdemeanor case.
yeah, so it's
That's where I
probably in
thought.
the.
Oh, he has a misdemeanor case?
It was probably in misdemeanor court that.
And
that.
John, West, would you be so kind to talk to him before we leave? I'm gonna assume he's going to be allowed indigency under these circumstances, but here's the file to look at. And Mr. West is a very good attorney, and he is one of our indigent defense lawyers, a public defender. So I want him to talk to you before we leave, sir. And I'm going to reset this for an announcement in 4 weeks. John, if there's any other appearances you feel like he needs to make sooner, let me know. But this court can't ignore the extraordinary, extreme, serious circumstances concerning what the court has in its file in the probable cause affidavit, which is what it relies on. That is all. You're taken into custody. And Brand, well, hold on. I have.
Will I be able to, you say you're taking me into custody?
Yes. Yes, you're in custody until you can post the $100,000 bond. You just can't write a check for it here.
Alrighty, friends. Well, we'll hopefully be able to keep an eye on this one and monitor it. Allegations are severe for sure. I will say, as much as we like Judge Stevens, and Michael was trying to point this out in the chat, the one word he's not overly good at is the word allegedly. He tends to just kind of grab right onto the charges and assume them as fact. So we'll see how things go. But that will do it for today. No, not for today. For this morning, because we'll be back tonight for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. Also, Barbara, if you could do me a favor and really quickly drop a link, if you still have it, to last night's In the Blind with Mike and Dan. If you want something to go watch next, go watch In the Blind with Mike and Dan if you didn't see it last night, because we had a really good discussion about prisons and kind of how they're broken and do they help people, don't they help people. It was a good discussion, so I think it's worth your while. If you have some time, go there next. And then join us for Sidebar tonight, 8 p.m. Eastern, 5 p.m. Pacific. And, of course, we'll be back tomorrow morning for this show at 9 a.m. Eastern, 6 a.m. Pacific. I think that's all the promos and plugs. Okie dokie, the wisdom I leave you with today is from the great Arthur Ashe, and I rather like this one for its simplicity. Start where you are, use what you have, do what you can. Think of how much better our lives would be if we all just did that. Start where you are, use what you have, do what you can. So think about all that. And we'll see you this evening. Take care. God bless.